The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Justice Gorsuch is participating remotely this morning. We will hear argument this morning in Case 20-843, New York State Rifle and Pistol Association versus Bruen. Mr. Clement.
Mr. Chief Justice, and may it please the Court, the text of the Second Amendment enshrines a right not just to keep arms, but to bear them. And the relevant history and tradition, exhaustively surveyed by this Court in the Heller decision, confirm that the text protects an individual right to carry firearms outside the home for purposes of self-defense. Indeed, that history is so clear that New York no longer contests that carrying a handgun outside of the home for purposes of self-defense is constitutionally protected activity. But that concession dooms New York's law, which makes it a crime for a typical law-abiding New Yorker to exercise that constitutional right. This court in Heller labeled the very few comparable laws that restricted all outlets for carrying firearms outside the home for self-defense outliers that were rightly condemned in decisions like Nunn against Georgia. New York likens its law to a restriction on weapons in sensitive places. But the difference between a sensitive place law and New York's regime is fundamental. It is the difference between regulating constitutionally protected activity and attempting to convert a fundamental constitutional right into a privilege that can only be enjoined by those who can demonstrate to the satisfaction of a government official that they have an atypical need for the exercise of that right. That is not how constitutional rights work. Carrying a firearm outside the home is a fundamental constitutional right. It is not some extraordinary action that requires an extraordinary demonstration of need. Petitioners here seek nothing more than their fellow citizens in 43 other states already enjoy, and those states include some of the most populous cities in the country. Those states, like New York, limit the firearms in sensitive places, but do not prohibit carrying for self-defense in any location typically open to the general public. I'm happy to continue by point.
Mr. Clement, sorry to interrupt you. If we analyze this and use history, tradition, text of the Second Amendment, we're going to have to do it by analogy. So can you give me a regulation in history that is a basis, that would form a basis for a legitimate regulation today? If we're going to do it by analogy, what would we analogize it to? What would that look like?
Well, Your Honor, I suppose if you're going to reason by analogy, then you could, go back and you could find analogous restrictions relatively early in our nation's history about prohibiting certain types of firearms or having firearms or any weapon really, in certain sensitive locations. And I think you could reason in that way. Here, I think the reasoning works the opposite direction, which is you typically have a baseline right to carry for self-defense. And the only historical analogs that really restricted the right of a typical law-abiding citizen to carry for self-defense to the same degree as the New York law here were those laws, very few, typically post-Reconstruction laws, that purported to eliminate any right to carry openly or concealed. And those laws were essentially invalidated by every court that was applying an individual rights view of the Second Amendment. And those decisions, of course, were exhaustively considered by this court in Heller, and those decisions were praised for their understanding of the Second Amendment and the relationship between the prefatory clause and the operative clause. And equally important, those laws were set forth by this court and singled out by this court as the very few restrictions historically that were comparable to what the District of Columbia was doing in Heller.
So if we look at you mentioned the founding and you mentioned post-Reconstruction, but if we are to analyze this based upon the history or tradition, should we look at the founding, or should we look at the time of the adoption of the 14th Amendment, which then, of course, applies it to the states?
So, Justice Thomas, I suppose if there were a case where there was a contradiction between those two, and the case arose in the states, I would think there would be a decent argument for looking at the history at the time of Reconstruction, and giving preference to that over the founding. I think for this case and for Heller, and I think for most of the cases that will arise, I don't know that the original founding history is going to be radically different from that at Reconstruction. But I guess what I would say is I do think that's about where it stops, because the point here isn't to look at history for the sake of studying history. The point is to look at the history that's relevant for understanding the original public meaning of the Second Amendment and the 14th Amendment.
Mr. Clement, how could it stop there? In Heller, we made very clear that laws that restricted felons from carrying or possessing arms and laws that forbade mentally ill people from doing the same. We, basically put the stamp of approval on those laws, and those laws really came about in the 1920s, didn't they?
Justice Kagan, I think some of those laws in their current form took that shape in the 1920s, but I also think there was a tradition from the beginning for keeping certain people outside of the group of people that were eligible for possession of firearms. I think obviously there was a different tradition with respect to felons, in part because, you start at the time of the framing and most felonies are capital crimes. So, the need to disenfranchise felons for firearm possession was a little different at the framing. So I think you do need to make those kind of adjustments. But I think those adjustments can be made. I think really there are two reasons to at least be skeptical of post-1871 history. I mean, the first is I just don't really understand why it's terribly relevant in forming the original public meaning of the Constitution. But of course, the second reason is it's just about that time that the collective rights view started to creep into the decisions of some state Supreme Courts. And I think, so in Heller's a perfect example that this court didn't absolutely stop its analysis in 1871, but when it looked at those later sort of post-bellum state Supreme Court decisions, the ones that relied on a collective rights view were given very short shrift. And I think that's the appropriate way to sort of deal with these historical analogs.
Well, I have two questions. One is on history. I mean, its law is history. In McDonald, we had professors of history, ran departments in the English Civil War, and they all said the history in Heller was wrong. You've read the briefs here. I don't know. You read the briefs of the historian of the Air Force, and she says it's this way, and the other one said it's the other way. How are we supposed to deal with that? There's a good case. This is a wonderful case for showing both sides. So I'm not sure how to deal with the history. My other question is I'm not sure what New York does. We're talking here about outside New York City. New York says we have about 90,000 licenses to carry concealed weapons, or maybe it's 40,000, or maybe it's 10,000. But there's been no trial, there's been no proceeding. All it is dismissal on the. So how are we supposed to find out what the history is, which is my minor question really. There's a lot of debate on that. But second, how are we supposed to know what we're talking about in terms of what New York does, since they say they give, including to one of your clients, they give a license to carry a concealed weapon. So there are concealed weapon licenses all over the place. So what are we supposed to do about those two things?
Well, Justice Breyer, let me start with the major question, which is, because I think that's actually very straightforwardly answered, which is there's no serious question about the experience of the individual petitioners in this case. And they both sought unrestricted licenses, and they were both denied unrestricted licenses, notwithstanding that they satisfy every other requirement that the state has to be licensed for concealed carry. And so I'm happy to debate why the state statistics don't really prove anything particularly relevant, but I think they're irrelevant for a more fundamental reason. I mean, if there were a debate between the parties about whether 95% or 90% of the citizens of New York were denied their confrontation rights in criminal trials, but you had before you two individuals who were clearly denied the right to confront the witnesses against them, you wouldn't worry about the other 95% or the other 90%.
That's not really the way your brief is written. The way your brief is written is to say, this is a regulatory scheme that deprives most people of the right to carry arms in self-defense. And your brief puts a lot of emphasis on that. I don't believe the state that they're going to really take seriously people's need for self-defense, because they always reject these licenses. If you had a bunch of statistics which suggests that the state is quite sensitive to people's need for self-defense and gives these licenses a significant amount of the time, you might think differently about the regulatory scheme, wouldn't you? I mean, that's the way your brief reads to me.
Well, Justice Kagan, 2 points. One is I wouldn't feel any differently with respect to my two individual clients who were denied their right to exercise their Second Amendment rights. But more broadly, the reason I'm so confident that this regime is problematic on its face is because on its face, at least as interpreted by the highest court in New York, the requirement you need to show in order to carry concealed for self-defense, but not for hunting and target practice, is you have to show that you have a need for self-defense that distinguishes you from the generalized community, from the general community. So New York's law on its face says that the only way that you can carry for self-defense is if you demonstrate your atypicality with respect to your need for self-defense.
So and that's because look, Mr. Koch can. He has his license. He can carry it for self-defense under the license to and from work, and as you say, can carry it for hunting, target practice, etc. Concealed. And in your opinion, is it supposed to say you can carry a concealed gun around the streets of the town or outside just for fun? I mean, they are dangerous guns. I mean, so what's it supposed to say?
It's supposed to be what New York says that they give to lots of applicants, at least in other counties, which is an unrestricted license, which basically means that somebody who has demonstrated to the state that they're of good moral character, that they have all the necessary training, whatever
So
the state requires.
40,000 or
whatever the state-
50,000 or 60,000 is not enough. You have to show you have a good moral character, and then if you just would like to carry a concealed weapon, which is a dangerous thing, as I said, you can just do it. That's what that's, in your opinion, that's what you want. No restrictions.
Well, certainly New York is entitled to have laws that say that you can't have weapons in sensitive places, in addition to whatever
No, I'm not saying
regulations have.
right. No, I'm not saying.
And New York has those laws, and we don't challenge those. What we're asking for, I mean, one way to think about it is we're asking that the regime work the same way for self-defense as it does for hunting. When my clients go in and ask for a license to concealed carry for hunting purposes, what they have to tell the state is they have an intent to go hunting. They don't have to say, I have a really good reason to go hunting. I don't have to say, I have a better reason to go hunting than anybody else in my general community.
Yeah, well, the difference, of course, you have a concealed weapon to go hunting. You're out with an intent to shoot, say, a deer or a rabbit, which has its problems. But here, when you have a self-defense just for whatever you want to carry a concealed weapon, you go shooting it around and somebody gets killed.
With respect, Justice Breyer, that's not been the experience in the 43 jurisdictions that allow their citizens to have the same rights that my clients are looking for. This is not something where we're asking you to take some brave new experiment that no jurisdiction in Anglo-American history has ever done.
Clement, may I? You're talking about 43 other jurisdictions. And I suspect that when we get into those 43 other jurisdictions, that there are going to be a handful that are identical. The one thing that I've looked at in this history is the plethora of regimes that states pick. And that starts in English law, through the colonies, through post-Constitution to post-Civil War to the 19th century to even now. Those 43 states that you're talking about, most of them didn't give unrestricted rights to carry in one form or another until recent times. Before recent times, there were so many different regulations. What it appears to me is that the history tradition of carrying weapons is that states get a lot of deference on this. And the one deference that you haven't addressed is, the question presented is, what's the law with respect to concealed weapons? In 1350, the British Parliament specifically banned the carrying of concealed arms. In colonial America, at least 4, if not 5 states restricted concealed arms. After the Civil War, there were many, many more states, some included in their constitution, that you can have a right to arms but not concealed. You can go to Alabama, Georgia, and Louisiana, which are now more open, are more free in granting the right to carry guns, but they prohibited, through their history, concealed weapons, the carrying of concealed weapons. It seems to me that if we're looking at that history and tradition with respect to concealed arms, that there is not the same requirement that there is in the home. One of the things Heller pointed to was there were few regulations that prohibited the carrying or the keeping of arms in homes. But that's not true with respect to the regulations about keeping of arms outside of homes. Putting aside the prohibitions, regulations on sensitive places, regulations on the types of people, it seems to me that I don't know how I get past all that history
Well,
without you sort of making it up and saying there's a right to control states that has never been exercised in the entire history of the United States, as to how far they can go in saying this poses a danger.
So, Justice Sotomayor, there's a lot to that question. I'll try to take it, sequentially if I can. I mean, let's start with concealed carry restrictions. I mean, it is true that during time periods where open carry was allowed, that some states did specifically restrict concealed carry on the precise theory that if we allow you to carry open, then if you're carrying concealed, you're probably up to no good. And Heller did exhaustively survey those cases. And what it concluded is that if a state allows open carry, then it can prohibit concealed carry. I suppose vice versa.
But you're asking us to make the choice for the legislature. We're only looking at concealed here.
We are not asking you to make that. And
well, yeah, you are, because you're conditioning history on a different fact.
I don't think we're asking for anybody to make that choice. In fact, the relief we've asked for is to have an unrestricted license because under New York law, as it currently exists, that's the only way that you can have a carry right for a handgun. But in framing our relief in the complaint, we framed it so that there are other relief consistent with the decision. So if New York really wanted to say, no, we have a particular problem with concealed carry, notwithstanding that traditionally that's the only way we allow people to carry. If they want to shift to an open carry regime, they could do that consistent with everything we've said here. Now, I don't think anybody expects that to happen because if you look at the New York law specifically, it's a law that prohibits the carrying of handguns except for permit holders. And then its provisions about permit holders speak specifically to concealed carry. So that's why we've framed our request the way we have. But what we're doing, I think, is completely consistent with the majority decision in Heller's analysis of the historical cases, which said that those very few states that tried to prohibit both concealed carry and open carry and so gave no outlet for the right to carry a firearm for self-defense outside the home, those were the laws that the Heller majority identified as being analogous to the D.C. restriction in Heller that was invalidated.
I do know that many of the laws conditioned or retain the right of the state to decide which people were eligible. And the historians to carry the arms, that you had to be subject to the approval of the local sheriff or the local mayor, et cetera. And during the Civil War, that was used to deny black people the right to hold arms. We now have the 14th Amendment to protect that. But why is a good cause requirement any different than that discretion that was given to local officials to deny the carrying of firearms to people that they thought it was inappropriate, whether it was the mentally ill or any other qualification? That's how I see the good cause, as fitting in within that tradition.
So let me make a point about how it's so different from that tradition, but then also let me make a historical point. It's radically different to say that if you are a typical New Yorker, so you satisfy every other qualification, you're not a felon, you don't have any mental health problems, you've done everything else we've asked you, but you are typical in the sense that you don't have an atypical need to carry for self-defense. I don't think there's any historical analog to that. As to the historical examples, with all due respect, I don't think I read the surety laws the same way that you do.
Yeah, guys, I'm just fine with that, Mike. Yeah, I'm just hanging out, man. I was looking for some stuff on this new Supreme Court justice, and it's kind of hard to find, but she's right there in line with Stephen Breyer, who is one of the justices on this case. So she's supposed to be right in his vein, and I just wanted to listen to some shit and see exactly where my old buddy Stephen Breyer was, because that's going to kind of tell me where this chick's going to fall. So, yeah, it's just an impromptu stream.
Those surety laws, which were only in place in a minority of jurisdictions, but nonetheless, I think they help us. because those surety laws, first of all, start with the proposition that there's a baseline right for every person, every member of the people protected by the Second Amendment to carry. And what they do is, if somebody essentially as a complainant can come into court and say that somebody has a propensity to use them in an offensive or violent way, then if you satisfy a neutral fact finder.
Hell, guys, there's a link up in the chat. If anybody just wanted to come in and shoot the shit, man, you guys are more than welcome.
Then you don't automatically get to disarm that person. You put them to the choice of posting a surety, and then they can continue to possess their firearm.
Mr. Clement, in your opening, you talked about the right applying in any location typically open to the general public. I'd like to get some sense about what you believe could be off limits, like university campuses. Could they say you're not allowed to carry on a university campus?
So, Mr. Chief Justice, I think the answer to your question is yes. And I think that what I would say, though, first of all, is the language I was talking about, any location open to the general public, that's right from the license denial on Joint Appendix page 41. So there wasn't loose language on my part. That's right there from where we are told in capital letters where we cannot carry. Any location, all caps, typically open.
Well, what sort of place do you think they could be excluded from? In other words, you can get a permit, but the state can impose certain restrictions. For example, any place in which alcohol is served.
So
and they say you cannot carry your gun in any place where alcohol is served.
So, Mr. Chief Justice, I think probably the right way to look at those cases would be look at them case by case and say, okay, in this court in Heller, for example, said sensitive places include government buildings and schools. I think those you can probably tap into a pretty good tradition. I think any place that serves alcohol would be a tougher case for the government. I think we would have a stronger case.
I'll be back.
To condition the license holder on not consuming any alcohol. There might be a variety of laws, and we could have those debates. But
what about the football stadium?
I think, again, football stadium, you probably take it on its own and look to the historical analogs. But here's, I guess, if I could offer some general principles. I think there's two principles. One is, restriction of access to the place is something that I think would be consistent with the way government buildings have worked and schools have worked. Not any member of the general public can come in there. They restrict access. With or without a gun, if you're an adult that has no business to be in a school, you're excluded. So I think that's a factor that would support treating that as a sensitive place. A second principle that I would offer is these sensitive place restrictions really are a different animal than a carry restriction, because I think a true sensitive place restriction is not just going to limit your ability to carry concealed, but it's going to be, say, this is a place where no weapons are allowed. Whether they're firearms or other weapons, no weapons are allowed. And then the third point that I would say, and this is just an analogy, but I think it's a useful analogy, is I think the way to think about this is a little like the non-public forum doctrine in the First Amendment, which is you start with the place, and you try to understand, is this a place where, given the nature of the place, its function, its restrictions on access, that weapons are out of place? And if so, that's probably a sensitive place where the state can say.
But I think what the Chief Justice is trying to do is figure out how those cash out in the real world. So I'll give you a few more. New York City subways.
So, I think that the question of whether you could restrict arms in the subways, you'd have to go through the analysis, I think, and say, is there restriction on access generally? I suppose.
No, I got the analysis, all three parts of it. Like, how does it cash out? What does it mean?
I don't know how those are going to cash out in particular cases, because I think the way that you would normally deal with that is you'd look at all the briefing we had in this case on the history of these various things. And so, on behalf of my individual clients, I suppose I could give away the subway, because they're not looking to go, they're not in Manhattan, they're in Rensselaer County.
The Chief Justice started with universities, and you said that would be all right. Did you mean that?
Yeah, yes, I did mean that.
Because that's open for, anybody can walk around the NYU campus.
Well, NYU doesn't have much of a campus.
I would go back to New York, and I think you'll find that that's wrong. Similarly, It's the Columbia campus.
Columbia's got a campus, and I don't know whether they restrict access at all. And maybe, if they don't restrict access to parts of the campus, maybe those are parts of the campus where they wouldn't enforce the policy anyways. The point I'm trying to make,
But
though,
you can't say, there are 50,000 people in one place, a ballpark. There are 50,000 people in one place. They're all on top of each other. We don't want guns there. That's you couldn't, the city or the state couldn't do that?
I think they might well be able to, because again, you can't get into Yankee Stadium without a ticket. I'd have to understand many of these, I don't know every jurisdiction. I don't know enough about Yankee Stadium, but, a lot of these stadiums are not run by the government anyway. So if a private entity wants to restrict access, I don't know where the state action is for there to be a
Suppose the
second.
state says no protest or event that has more than 10,000 people.
I think that might be, trickier. Maybe they could justify that under strict scrutiny, but I don't think that would be a sensitive places
But why
restriction.
not? I mean, I guess it's about the level of generality. All these questions that Justice Kagan's asking you or that the Chief asked you, if you concede, as I think the historical record requires you to, that states did outlaw guns in sensitive places, can't we just say Times Square on New
Yeah, Bacon, I don't know how long I'm going to be on. I'm just hanging out. So I might be on. It's just, there's no damn telling, man. I took the week off this week with my kids because my daughter is on spring break this week. So I get to be the night owl that I normally am, and I don't have to wake my happy ass up at least too early in the morning.
Year's Eve is a sensitive place because now we've seen, people are on top of each other. We've had experience with violence. So we're making a judgment. It's a sensitive place.
So here's what I would suggest, that the right way to think about limiting guns in Times Square on New Year's Eve is not as a sensitive place, but as a time, place, and manner restriction. That would be a perfectly reasonable time, place, and manner restriction. But I don't think that's the sensitive places doctrine, as I understood it, and obviously it's a brief reference in the Heller decision, so I may not fully understand it. But I understood that those were certain places where there were just no weapon zones all of the time because of the nature of that institution. And I think it's probably worth thinking about
You guys that are listening, can you hear that okay with it down that far?
restrictions, but they would be done
Mr. Clement,
under the rubric of time, place, and manner.
Could we start with the purpose of the personal right to keep and bear arms? And the core purpose of that right, putting aside the military aspect, is self-defense. So starting with that, could we analyze the sensitive place question by asking whether this is a place where the state has taken alternative means to safeguard those who frequent that place? If it's a place like a courthouse, for example, a government building where everybody has to go through a magnetometer and there are security officials there, that would qualify as a sensitive place. Now, that doesn't provide a mechanical answer to every question, and but would that be a way of beginning to analyze this?
Justice Alito, that might be a way of analyzing it. The reason I'm a little bit reluctant to go that route as opposed to really think about the nature of the place and the restrictions that are associated with its core activity is because I worry that if you went
Okay,
that
good deal,
direction,
guys. I
the
just
state
wanted
would
to
say, well,
crank
this
it down a
part of the
little
city,
bit
we
where I
have a
didn't
lot
have to
of
pause
police
it to talk,
officers,
but
and
you guys
so
could still
you
hear
really
me.
don't need to exercise your own individual self-defense right there because we have your back. And
Well,
I don't think that's...
I don't know what those places would be, but continue.
Well, I think my friends would tell you that, the whole city of New York is that way. And I think there are a lot of people in New York, and New York may have a lot of reasons to have regulations that are a little bit different than in upstate New York where my individual petitioners reside. But I don't think that they can take all those people in New York and deny them of their fundamental constitutional
How do we
But
do
you
this?
just said-
Justice Breyer?
How? I mean, so far we've been, to my mind, I think NYU does have a campus. You're not certain. All right?
Now this is just a Stephen Byer talking right now, so you'll get to see his intellect. And like I said, this new Supreme Court justice clerked for this guy and is right there in his vein, his way of thinking, and it's probably more radical than Byer is.
I think that in New York City, people should have considerable freedom to carry concealed weapons. I think that people of good moral character who start drinking a lot and who may be there for a football game or some kind of soccer game can get pretty angry at each other. And if they each have a concealed weapon, who knows? And there are plenty of statistics in these briefs to show there's some people who do know. And a lot of people end up dead. Okay? So, what are we supposed to do? To sort of float around, like with NYU, and say, hey, this is the rule. It seems to work out in upstate New York. We don't know, of course, and we do know that your client is carrying a concealed weapon because he has a right to in some instances, and even following Heller and following the history, which I thought was wrong. Even so.
So yeah, this guy completely thinks the Heller decision was wrong. I think the Heller decision was a punt. It should have been a much easier and much clearer defense of the Second Amendment. But Byer's completely against that shit. So we know where Ketanji Brown is going to stand on this shit. That's one of the reasons I wanted to go back and listen to this, just to kind of get a feel for it. I mean, granted, she's not going to change the balance of the court, but unless something happens and they end up packing the court. Yeah, NYC had that due cause or whatever it was requirement to actually be able to carry a firearm, and then you had a couple of different levels of permit. Like one permit would allow you to leave your home with the gun, drive right to the range, go to the range, and then drive right home. But if you stopped for gas, they could possibly say that you were outside of that license. And it's extremely hard to get a concealed carry license. Matter of fact, John Stossel, if you don't know who he is, he's a pretty big libertarian guy who started out as a leftist. He did a big piece on the carry laws in New York a couple of years ago. It showed just how insane they are. But Byer's right there. Byer doesn't think you should have a gun at all, much less be able to carry one. Concealed, open, loaded, unloaded, he doesn't care.
What are we supposed to say, in your opinion, that is going to be clear enough that we will not produce a kind of gun-related chaos?
So, Justice Breyer, I would sort of point you to two things that maybe would give you some comfort. I mean, one is the experience of the 43 states, and there are amicus briefs on both sides getting into the empirical evidence, but there really isn't the case that those 43 states that include very large cities like Phoenix, like Houston, like Chicago, they have not had demonstrably worse problems with this than the 5 or 6 states that have the regime that New York has. So that's why.
Now, the amicus briefs are what they call friend of the courts briefs, where people write in either in support of a certain opinion or against a certain opinion. A lot of the people who wrote against the New York loosening its carry laws were people like Moms Demand Action, Giffords Law Center, Everytown, Bloomberg. They were the ones all saying if they loosen restrictions, there's going to be blood in the streets. Like they ain't killing motherfuckers like it's free in New York anyway.
One place to look. The other place that I think you would find something persuasive there is their own amicus brief on their side by the city of Chicago. Because the city of Chicago is in a shall issue jurisdiction. And the city of Chicago goes on to sort of, essentially brag about all of the ways that they've done consistent with that regime to reduce crime in Chicago that probably doesn't have a direct analog in downstate Illinois. But of course, one of the problems with this case.
I mean, most people think that Chicago is like the world's worst city with respect to gun violence, Mr. Clement.
Chicago and their corporate
And Chicago doesn't think that, but everybody else thinks it about Chicago.
And nobody thinks that about Phoenix, and nobody thinks that about Houston, and nobody thinks that about Dallas, and nobody thinks that about San Diego, which, even though it's in a restricted state, is a shall-issue jurisdiction.
Mr.
Thank
Clement,
you, Mr. Clement. Justice Thomas, anything further?
Mr. Clement, where does Mr. Nash live?
Mr. Nash lives in Rensselaer County, New York.
Is that close to NYU?
That is nowhere near NYU, Justice Thomas. And, I think if you look at the county website, they talk about their 153,000 people spread over 955 square miles. And yet that's the context in which my individual clients are being denied their Second Amendment rights.
Justice Breyer, anything further? Justice Alito? Justice Sotomayor?
Counselor, your client is permitted to, Mr. Nash, one of the two, to carry when engaged in outdoor activities of any kind, like camping, hunting, and fishing on back roads. With the few substantially lesser number of people, tell me how many places in Rensselaer County does your client have a self-defense risk? I mean, at what point do we look at the restriction and the burden it places? Meaning, yes, I'm sure it has a center of town. I'm sure it may have a shopping center or two. But it's not like he's totally restricted from carrying a gun. He's just restricted from carrying one basically in those sensitive places. Because the rest of his home is pretty distant from other homes.
So when, and this is an argument that I've had with people who are in the vein of these idiots who are anti-gun, when are you at the greatest risk for someone robbing you or shooting you or anything else? It's when you're out around a bunch of people that you don't know in public. People are less likely to want to kick my door in and come in my home than they are to rob me when I'm out on the street with my hands full of bags and boxes and shit like that. These people's arguments are absolutely insane.
So just so we start on the same wavelength or the same page, literally page 41 of the joint appendix, this tells Mr. Nash where he can carry concealed. And what the officer, McNally, told him was, quote, "I emphasize that the restrictions are intended to prohibit," italicized, "you from carrying concealed in any location," all caps, any location, "typically open to and frequented by the general public." Now, I would submit that's a pretty broad number of places in Rensselaer County, and it would include, I fear, most of the roads in the county at night when you're traveling and might think that you need. I mean, if Mr. Nash has a relative whose car breaks down and has to have a change of tire, and he wants to go out and assist them with that and wants to make sure that he is in a position to defend himself, I don't think he can do it consistent with this license restriction. And at the end of the day, I think what it means to give somebody a constitutional right is that they don't have to satisfy a government official that they have a really good need to exercise it or they face atypical risks.
Justice Kagan, anything further?
Mr. Clement, you said, I think in passing, that it would be fine if New York banned open carry so long as it allowed concealed carry. Is that correct?
Certainly that's consistent with the relief we're looking for. We're looking for some outlet to exercise our constitutional right to carry firearms outside the home.
How is it consistent with the history? I mean, the history seems very clear to me that it's sort of like the exact opposite of how we think about it now.
Yeah, Bacon, you're right. The hypotheticals they're coming up with are a bunch of horse
to
shit.
display their arms as a matter of transparency, and what they prohibited was the concealed carry. So I'm thinking, like, if you look to the history, you end up with a completely different set of rules from the ones that you're suggesting with respect to concealed versus open. And it's an example, I think, of the difficulties of looking to history, where people were operating on such different, to use your term, wavelengths.
So, Justice Kagan, first of all, I would have thought that, we'd sort of cross the bridge to use history in this context in Heller. But if we're going to look to history, I actually think
Mr. Clement, the question is how to use history. And, where do you look? How far do you look? Do you look to the 1920s when all these felon laws were passed, as well as public purpose laws of exactly the same kind as New York? So one question is, how far up do you look? Another question is, with what sense of flexibility do you look? And I think that this is an example of that. It's like, no, we're not going to ask for an exact analog because we realize that the world has changed and regulatory schemes are very different because regulatory interests are very different. If we tried to copy history, we would find ourselves in a world in which the only thing that a state could do is tell people, you can't carry it concealed, you have to carry it open.
So, Justice Kagan, let me give you an example of how I think the court should use history in this context. And I'll go exactly to the Georgia statute that was at issue in Nunn against Georgia. Now, that was a statute that on its face prohibited carrying simpliciter. So it didn't say open, it didn't say concealed. Now, the court that analyzed that reversed, vacated the indictment of somebody under the statute because the statute didn't specify and they didn't think that person had carried concealed. But when they looked at it, they interpreted it in light of the context at the time, and they thought, boy, it is not consistent with the Second Amendment that that court actually thought directly applied to the state, which is interesting. But they said that's not consistent with the Second Amendment to prohibit any means for carrying. Then, consistent with kind of the norms of the time, kind of almost as like a severability holding, dare I say it, they said, well, all right, the open carry, that's allowed. I mean, rather, that's we're going to say that to the extent this statute prohibits open carry, that's unconstitutional, but to the extent that it prohibits concealed carry, that's constitutional. Now, the fundamental problem with the law that carries over as a direct analogy is it gave no outlet to exercise the constitutional right to carry for self-defense. The norms of the time had a favoring for open carry over concealed. I will grant you that the norms of the time have flipped, and certainly in New York, based on the rest of their licensing regime, I assume that they would prefer that my clients carry concealed rather than openly. But I think that's the way you can use the history, and you can use it with some contextual sensitivity, but you cannot sort of, throw it all out, because I do think the analogy is pretty clean between a law that prohibits any form of carry and what New York is doing here. And of course, that was one of the laws that...
See, when Elena Kagan questions him on this, you have to realize that she is completely anti-gun and she's looking for any excuse or any reason to basically deny this case. As far as I know, the opinion on New York State Rifle and Pistol hasn't come out yet, but it should be coming out sometime soon, I think. So we'll see. The composition of the court right now, they should come down pretty easily on the Second Amendment end of this, but we'll see what happens.
This court specifically looked to in the Heller decision as well.
And when you look at this history in the properly contextual way, do you see no difference between the kind of regulation that was allowed in the home and the kind of regulation that was allowed in public places? Because it seems to me that the history, and Justice Sotomayor developed it at some length, but the history is replete with that distinction. And indeed, Heller recognizes that. Heller recognizes that the home is a very special place, both because, for similar reasons for the Fourth Amendment, but also because the need for self-defense is so much greater there.
So I think in terms of, I'm not going to tell you that the context doesn't matter at all. I mean, take sense.
That's That is an argument that drives me insane. Why does my need for self-defense lower when I leave my home? I don't have a bunch of people walking around in my home that are going to rob me. When I go out into public, much like my dad getting robbed a few years ago, just stopping at the store to get coffee and a pack of smokes at 5 o'clock in the morning and having someone put a gun in your face. Never seen that happen at my home. Why does my need for self-defense lower to these people when I actually leave my home?
Places law, right? They don't really affect the keep right the way that they affect the carry right, unless you try to say the entirety of Manhattan is a sensitive place, and then they might affect both. But in general, the analysis is going to be slightly different. But I would say that, I don't think those differences are material here. I think if the district, instead of just banning handguns inside the home, had adapted a permitting regime that required district residents to show that they had an atypical need to possess a handgun inside the home, I'm not sure anything in Heller would have been different, because it's just inconsistent with a constitutional right to either ban the exercise of it or say that it's a privilege that you can only exercise if you show that you are atypical to the rest of the people who are equally protected by the constitutional right.
Thank you.
Mr. Clement, are you able to hear me?
Loud and clear.
Right. Some of your amici have asked us to provide further guidance to lower courts in cases beyond your own. And so putting aside your case for the moment, they've pointed out that some lower courts have refused to apply the history test, for example, and said they will not extend Heller outside the home until this court does. Other courts have applied intermediate scrutiny and variations of that. Some have suggested that strict scrutiny would be appropriate to treat this right comparably to other rights under our modern tiers of scrutiny. I'd just be curious what views you.
That's another reason I say that Heller was an absolute punt, because it should have affirmed the right to self-defense with whatever weapon that a person sees fit to use, and in any given situation. And a lot of states are still refusing to apply any of the Heller decision to their actual gun cases. So yeah, right, Bacon. Yeah, it's fucking bass backwards, to be sure. Sarge, do you know the date when do they have a date when the opinion on this is supposed to come out, or did they just give us like, hey, it's supposed to come out in between this month and whatever month? I can't remember. It's been a little bit since I've looked at it.
Have about all that.
Thank you, Justice Gorsuch. I think we would start with the idea that text, history, and tradition is an appropriate way to deal with this right. That's what the court said in Heller. I think this court would allow the court to make clear that the same analysis applies outside of the home. And I think this case, like Heller, is such an outlier that the court wouldn't have to say too much more unless it wanted to. I think if it wanted to, though, it would already, I think, go a long way to correcting some of the mistakes in the lower court to say that text, history, and tradition is the test, not part of the test, but the test inside and outside the home. And if this court prefers to go the level of scrutiny route, I would simply say two things. One, we would prefer strict scrutiny as being consistent with a fundamental constitutional right. But even if it's going to be intermediate scrutiny, probably the single most important thing to remind the lower courts is that intermediate scrutiny requires narrow tailoring. And a law like this that takes a person who has no proclivity whatsoever, unlike the surety laws, to misuse firearms, and says you simply can't carry them for self-defense anywhere frequented by the public because you haven't demonstrated an atypical need, I mean, that's about as untailored a law as I can imagine. So I think if you did one of those two things, Either make clear that it's text, history, and tradition outside the home as well as inside, or made clear that narrow tailoring is an integral component of the test. That would go a long way to clearing up some of the confusion in the lower courts.
And I know you've had a substantial debate with your friends on the other side about the Statute of Northampton. We haven't heard about that today, and I just wanted to give you a chance.
Thank you, Justice Gorsuch. I'd say just a couple of quick things about the Statute of Northampton. First of all, I think that it was very clear from the Knights case and the treatises that this court relied on in Heller that by the time of the framing of the English Bill of Rights, that was not a general prohibition on carrying outside the home, but was a prohibition on either carrying unusual and dangerous weapons or using common weapons in a way that terrorized the public. And so I don't think that that supports the other side's position here. And the second thing I would say is that probably the single most obvious point about the history is there just are no reported cases on this side of the Atlantic, not in actual reporters, not.
Yeah, that's about what I thought. Sometime I thought it was going to come out sometime this summer. And it's going to come out probably after the ATF new rulings comes out, which is going to be a fun time too. Hey, what's up, Crow? Yeah, we all radicals in here, man. This is just an impromptu stream, man. I'm normally not streaming this late, but I'm off this week because the kids are off. So I'm hanging out with my kids versus getting babysitters. So I'm just pulling my old night owl shit.
Newspaper reports about crimes of the day that show anybody being prosecuted for a violation of the Northampton crime simply by carrying common firearms for self-defense. And the one U.S. early court that dealt with this, the common law equivalent of the statute, was State against Huntley in North Carolina, which was an opinion that was cited favorably in the majority opinion in Heller. And that case went out of its way to say that simply carrying firearms per se is not an offense. It's the intent to terrorize the people that is prohibited by Northampton.
Thank you.
Justice Kavanaugh?
Mr. Clement, I have several questions. First, I want to make sure I understand your main problem here with this permitting regime, as I understand it, is the discretion that's involved with the permitting officials, and your point that that's just not how we do constitutional rights, where we allow basic blanket.
Yeah, Crow, I got a frame coming in, and I am drooling over some AK parts kits that I really, really want. And it's hurting because, like I said, I really, really want them. So that's where I'm at. Yeah, I'm trying not to pull the trigger on some things, relatively speaking. Yeah, dude, I've got a 10.5 build that I did, what, a year, 2 years? No, hell, it's been a little over 2 years ago now. And I love that thing. That thing is freaking nice. Yeah, these people baking, it would be so easy just to short circuit all of their damn arguments half the time. It's amazing to me that these are the people who are basically deciding how these laws are going to work or if they're constitutional or not, considering apparently they're not literate enough to actually read the Constitution and understand it.
Discretion to grant or deny something for all sorts of reasons. But I understand you would not object or do not object to the regimes that are used in many of the other 42 states, the shall issue regimes. I mean, there could be particular problems with those, but I do not understand you to object to shall issue regimes. Is that accurate?
That's accurate, Justice Kavanaugh. And as you say, there are especially if you have something like good moral character, there is the possibility for discretionary abuse in those regimes as well. But the thrust of this case is, we'd like what they're having. We'd like what the people in the other 43 states. Dude,
Crow, you don't even have to go with just to get your thing, man. You don't have to go to a flat anymore. You can get a pre-bent receiver, and then you can just use the jigs to do the cutout for your safety selector, and then your drill holes for your pins and all that. The first gun I ever built, I did a flat and built the jig to bend it and everything. But you don't even have to go through that headache anymore. You can go to right to AK Builder and get a pre-bent receiver. A lot of them, or some of them, will already have the center support rivet in. Some of them won't. I prefer them without the center support rivet in because it makes it easier to crush your trigger guard rivets, because the center support's not in the way, and you've got a little bit more room to work. But yeah, you can go with a pre-bent, and it makes life a lot easier. You don't have to get the bending jig to do a flat jig or a flat bend, and it knocks probably $250 out of the equation. Yeah, man. The biggest thing about AKs or building AKs is the amount of money for the tooling to do it. I did a video that I sent to Dark that's at some point in time is supposed to pop up on CRS's channel. I did that video to go on his channel since he's not producing content, and just went over the general tools to build an AK and a couple of different types of tools you can use. You're looking for your parts or your tools to build the gun are going to be as expensive at least as the parts kit itself, unless you know someone with some tools that you can borrow. AK Builder, as far as receivers, I had another one laying around here somewhere. The receiver, you can get it pre-bent. And then, like I said, you can get their jigs and stuff that the receiver sits in, and then you just drill a few holes and then do some filing on it to connect holes for like your selector lever and all that. It makes it a lot easier than starting out with a regular flat and then having to have a spot welder to weld in rails and all that shit. It's a lot easier starting out with that pre-bent receiver. Oh, hell yeah, Crow. Dude, there's a lot of guns I would love to build for sure. I still want to do a set me. And God knows there are, it's actually cheaper in a lot of cases to buy some of these machine gun kits than it is a freaking rifle you're going to build as a semi-auto. One of these days when I grow up and get everything off the ground and get my my SOT, it's gonna be fun. It's gonna be interesting. Yeah, 0702. That's it.
Are allowed to do and exercise their rights, and in many of those states it's shall issue, and that is, of course, New York purports to have effectively a shall issue regime with respect to hunting. The only other caveat I wanted to add is it's the discretion combined with the atypicality requirement. So if they came up with some sort of like magic wand that gave them a precise reading of typicality, and so there was no discretion, but the standard was still, at the end of the day, you have to show that you are atypical from the rest of the people protected by the Second Amendment, we would have a problem with that as well.
Right. A shall issue regime with an atypicality requirement wouldn't be no good in your view.
Exactly, even if it could be somehow, if you could come up with some objective standard of typicality.
Okay, and the issue before us, as I understand it, is the permitting regime. We don't have to answer all the sensitive places questions in this case, some of which will be challenging, no doubt. Is that accurate?
That's 100% accurate. There's sort of a market test of the accuracy of that, which is New York does have sensitive place laws, and we have not challenged them in this litigation.
Yeah, it'd be interesting to try to do your own binary. But here, I'll show you what I was talking about with the receivers. So I picked it up. You can get a receiver that looks just like this off of AK Builder, not with the paint on it, but it's a pre-bent receiver. It's already got the rails welded in it. It just won't have the holes cut for your safety selector, and won't have your pinholes and everything drilled. But what you do when you get the flat, if you've got their jig, I'll turn the damn light out. Anyway, you can slide that into that jig, and this jig will give you all your alignment for your pinholes, and that's for your safety selector up here. Drill a big hole, drill a small hole, connect the two holes. That will actually do your hole for your safety selector and all that, and it keeps everything lined up real well. So you don't have to go. See, this is a flat that I bent, so no rails welded in or anything. I haven't done anything with this receiver, but this one also isn't heat treated. So the ones you can get now that are already bent are also already heat treated. So you don't have to sit there and fuck around trying to heat up holes and quench them and everything to heat treat just the holes. The whole receiver is going to be heat treated. That's what I built the side folder out of. Was a receiver I got off of AK Builder, already pre-bent, and it already rails already welded in, all that. So all I had to do was drill the holes, cut out a little section, filing everything down, and then of course, then you got to drill all your rivet holes, match them up with your trunnions, and then crush all your rivets. And you can go with either AK Builder style tools, or there's a company called Toth Tools. TOTH, I think, Toth Tools. They've got stuff where all their stuff is based around not having like a press. So you can take a regular vise and a couple of hand tools, and you can crush all the rivets. You can do everything as far as the receiver goes right there on your kitchen table. Press the barrel in and out, all that shit. The only other big piece of equipment you would need would be the drill press. They actually make rivet jaws for a set of, I think, 24-inch bolt cutters. You pull their jaw or pull the old jaws off, put the Toth tools on, and you can reach inside the trunnions and crush all your rivets with it. I built my original tools very similar to that. Who the hell is messaging me right now? I have no idea. But yeah, I used, or basically built all my original tools off of their pattern to build the first AK I built. And they've got some really good shit. Matter of fact, their barrel press is what I like to use to press my barrels in, because they make it really easy to headspace. Matter of fact, hell, I'll show it to you. We're not doing the share the pain stream, so I can fucking goof off. So, believe it or not, this is a barrel press from Toth Tools. So, whether it's in a receiver or what, you clamp these off in a vise around your trunnion. Just trying to find my camera. Clamp them off in your trunnion. And then this piece right here will actually press your barrel in. So all you do is slide it up, tighten it up, and then use a wrench on that nut, and that will press your barrel in. You can also press your barrels out with it. All you got to do is basically flip the tool around. So you don't even need a vise, or don't even need a press to be able to push your barrels in and out. A little bit harder fighting your pins without a press, your barrel pin, because some of those are freaking tight, but I mean, it works great. And if you're starting off with a barrel that's not headspace to your trunnion yet, you can bring that in so even that it makes head spacing real easy. Oh, dude, I made my first one. My first one is around here somewhere. Oh, here it is. So when I looked at this crap, I didn't have any measurements. I just took basically their pictures and made it up as I went. So when I built mine, I overbuilt the shit out of it. So the blocks are probably one of the most important thing because you've got to have recesses in them to go around your rivet holes or around the heads of the rivets when you're pressing a barrel into a receiver. But yeah, I mean, I built those. And matter of fact, I still use this press in a lot of cases. So yeah, it can definitely, you can definitely do it. Matter of fact, this was my original press to do my long rivets, like my center support rivet and stuff like that. And all you do is you use these two bolts at the top to tighten things down. And then I made the pin out of an old drill bit, and it's got a concave hole on the inside of it. So when you tighten that up, it crushes that rivet down. And then I made a bucking bar for the backside to do the same. So yeah, I did. The first AK I built all my tools to do it. From the thing to bend my flats, the whole 9 yards. And then after I proved that I could do all that shit, then I started investing in the AK builder tools. So the rivet works a lot cleaner. It makes things a lot easier on you. You're dealing with tools that have been perfected over many years versus someone like me just going in and learning how to mill and machine to make the tools. Yeah, dude. Yeah, the tools and stuff, the router tools and jigs and stuff to do a 80% AR, like this receiver. Hell, even with the router, you could probably get away with less than $250 to mill your trigger pocket and all that, and to drill your holes for your pins and everything in it. Not that expensive. All right, Sarge, you take it easy, brother. Yeah, when we're looking at all the stuff to build an AK, you can easily drop $600 on the tools to build an AK. That shit gets expensive. What I would recommend if you had a couple people wanting to build an AK is everybody spend some money on some tooling and well, you're not supposed to have so-called build parties anymore, but what the ATF don't know won't get your dog killed.
And then to follow up on Justice Thomas's question and also Justice Gorsuch's, we should focus on American law and the text of the Constitution, and we don't start the analysis in a vacuum, but we start it with the text, which you say grants a right to carry, and then historical practice can justify certain kinds of regulations, but the baseline is always the right established in the text, and there'll be tough questions as the arguments revealed about what the historical practice shows, but the default or baseline is the text.
That's absolutely right, Justice Kavanaugh, and of course that's no different from something like the First Amendment, where of course you start with the text, and it's very emphatic text, no law abridging speech, but then you look to history and tradition just to realize, oh, well, there's a long tradition of treating defamation and libel different going back to the framing, so you use that history to inform the text, but the focus is on the text.
And last question, following up on Justice Gorsuch's question, as he points out, some courts have used intermediate scrutiny or strict scrutiny. Those are balancing tests. I think Professor Alcia's amicus brief is very helpful on that. There's well-developed law in other areas, but it'll be no surprise to you. I have concern that would just be a balancing test that would make it a policy judgment, basically, for the courts. And I don't know why we would. You say you'd be okay with that, but I'm not sure why we would smuggle all that into here, and then it would just be a policy judgment that would be unanchored from the historical practice.
So, Justice Kavanaugh, 2 points just in response to that. One, as you articulate the concerns with interesting balancing, that might be a reason that if you're going to go with the level of scrutiny's approach, you would go to strict scrutiny, where I just think there's less play in the joints. But the second...
Maybe, but what's a compelling interest? Do you have a compelling... there's a lot of play in the joints in some of the other areas, so I don't know that you want to open that door. But.
And the second point I was going to make, though, Justice Kavanaugh, which is maybe more consonant with the thrust of the question, is, whatever was the case in Heller, where I sort of read the majority opinion as actually already rejecting interesting balancing, but whatever was the case in Heller, we now have this 13 years of experience with lower courts applying the test. And in our view, they've made a muddle of it, and it's probably the experience of the last 13 years is probably a very good reason to prefer a text, history, and tradition approach to this area of the law.
Thank you.
Justice Barrett?
Mr. Clement, I have one question. So a couple times, in response to my question about Times Square and New Year's Eve, and then just now as well to Justice Kavanaugh, you made reference to the First Amendment. And obviously, a lot of the questions that have been asked have been focused on how can the state fairly regulate? Because everybody agrees there have to be some regulations, and it might not be the case that we can always find exact historical analogs. So returning to the First Amendment, in response to me, you said, well, that might be analogous to a time, place, and manner restriction. So do you think the First Amendment and the edifices that we have structured around it would be a helpful place to look? Is that what you're suggesting?
Well, I'm suggesting that there is a lot of useful teaching in the First Amendment. I'm not sure I'm suggesting you should just take sort of doctrines lock, stock, and barrel from the First Amendment. But, going back, well over 100 years to like Robertson, when the court was just talking in dictum about the First and the Second Amendment, it drew the analogy between allowing some restrictions on the Second Amendment and, in the First Amendment context, the First Amendment being consistent with libel and defamation. As I suggested to the Chief Justice, I think the way you think about a non-public forum and why that's different from First Amendment purposes from a park, I think could be useful in some of these contexts. If you focus on the nature of the location, you might say this is inappropriate for weapons, but in the same way as in the First Amendment, you just don't get to say, well, we're going to make it a non-public forum.
No, man, I haven't seen anything about that. Yeah, Bacon, that whole, I think we can agree we need some regulations is absolute horseshit. Because, no, I don't agree that any regulations on firearms should happen. I mean, the only regulation I should have on my firearm is the same regulation that is on any other thing. I don't have the right to wrongfully deprive someone else of life, liberty, or property. That's the only regulation that we should be looking at. And that would apply to a knife, a fork, a spork, a spoon, you name it.
Forum by saying no First Amendment activity there. You can't just take a location and say we're going to make this a sensitive place by saying no Second Amendment activity there. So those kind of analogies, and lastly, the analogy being you look at a law that says no concealed carry in a particular place on one night of the year, quite differently from a law like this that says there's really no way for a typical New Yorker to conceal carry anywhere that the general public is allowed to go. Those under the First Amendment, those are radically different laws, and I think under the Second Amendment, those are radically different laws.
I see where you're going with it, Crow. It's kind of like the old Russian revolvers where the cylinder would actually move forward and make a gas seal at the chamber. So is it something you can add to like a regular 22 LR, or is it just a 22 LR that actually functions that way, where when you pull the trigger, the cylinder slides forward and creates a gas seal? Because if it was something you could add on to revolvers, that would be pretty fucking tricked out.
Thank you.
Thank you, counsel. General Underwood.
Mr. Chief Justice, and may it please the court, for centuries...
Now, this chick who's going to start talking now is the opposing counsel. She is the one for New York State who is against any form of carry. Dude, that's badass. If they can come up with more things like that, revolvers would be pretty tricked out. Being able to compress or suppress something like that or silence it, that would be pretty fucking badass.
English and American law have imposed limits on carrying firearms in public in the interest of public safety. The history runs from the 14th century Statute of Northampton, which prohibited carrying arms in fairs and markets and other public gathering places, to similar laws adopted by half of the American colonies and states in the founding period, to later state laws that relaxed restrictions for people who had a concrete need for armed self-defense.
Now, here's my issue with some of the arguments she's proposing, that there were restrictions on firearms back then, so we should have restrictions now. That's horseshit. That just means that those restrictions back then were bullshit then, so restrictions now are bullshit on top of bullshit. Much like we had slavery during those times. Slavery was horseshit then. It would be horseshit if we did slavery now. So having slavery then wouldn't justify having slavery now. I don't see why these people can't make these connections.
Starting as early as the early 1800s, states began taking different approaches to regulating firearm carrying in public. Some states provided that a person who carried firearms in public without reasonable cause could be arrested and required to post a bond. Other states made it a misdemeanor to carry a handgun without reasonable grounds to fear an attack. Other states and territories banned carrying handguns in towns and cities altogether, or restricted it to situations of immediate threat. And in the early 1900s, many states made good cause a requirement for a license to carry a concealed handgun, while also prohibiting, in some cases, the open carrying of handguns. In total, from the founding era through the 20th century, at least 20 states have, at one time or another, either prohibited all carrying of handguns in populous areas or limited it to those with good cause. New York's law fits well within that tradition of regulating public carry. It makes a carry license available to any person, not disqualified, who has a non-speculative reason to carry a handgun for
just to shoot the shit.
New York is
that
not
is the
an
upper
outlier
to my
in the extent to which
10
the
and a half
state
inch
restricts the ability to carry firearms in public,
pistol.
And it's not an outlier in asking a license applicant to show good cause for a carry license. Many ordinary people have received carry licenses in New York State. If the court has questions about how the law works in practice, it should remand.
And if you're looking for a good sling,
a
good 2-point adjustable sling, Blue Force gear, this sling is fucking great.
General Underwood, you seem to rely a bit on the density of
there be my 10-year felony lower.
I think that states like New York have high density areas. And the implicit in that is that the more rural an area is, the more unnecessary a strict rule is. So when you suggest that, how rural does the area have to be before your restrictions shouldn't apply?
Well, I think the way the New York statute works is consistent with a reasonable rule, which is that there's not a cutoff, there's not a number at which things change, but that licenses, unrestricted licenses, are much more readily available in less densely populated upstate counties than they are in
So in a lessly populated area, you could possibly get a carry license, but in a place that is more populated where you are more likely to get fucking robbed, you don't have the right to defend yourself. That's where this chick's going. And Clarence Thomas just nailed her down right there, and she's trying to squirm away from it because Clarence Thomas was basically asking her, where's the cutoff? Basically, how many people per square damn acre does it have to be before a person can or cannot get a carry license? And like she just said right there, well, there's not a real number. Yeah, okay. All right.
Dense metropolitan areas, and that is a virtue of the system of having licenses handled by licensing officers who are part of the local community and who take the density of population into account, as well as the many other factors.
Well, Mr. Nash lives in quite a low density area. That's why I'm interested in where your cutoff is. It's one thing to talk about Manhattan or NYU's campus. It's another to talk about rural upstate New York.
He actually lives in what I would call an intermediate area. He lives in Rensselaer County, which is not that far from Albany, and it contains the city of Troy and a university and a downtown shopping district, but it also contains substantial rural areas, and that is precisely
So
what the
if you
licensing
live in
officer
bumfuck
here
Egypt,
was
but you
taking
could
into
possibly
account
make
when
it to a
he
city,
made the
you still
differentiation
can't get
between,
a license.
don't take it to the shopping mall, don't take it downtown, but you can take it in the sort of backcountry areas.
Thank you.
General, you mentioned that the gun is, I guess permits are more readily available in a less populated area.
Unrestricted permits.
Unrestricted permits.
Are more readily available in less populated areas, yes.
Now, Heller relied on the right to defense as a basis
that's about
for its
right.
reading of the Second Amendment, or that was its reading. Now, I would think that arises in more populated areas. If you're out in the woods, it's pretty unlikely that you're going to run into someone who's going to rob you on the street. On the other hand, there are places in a densely populated city where it's more likely that that's where you're going to need a gun for self-defense. And, however many policemen are assigned, there are high crime areas. And it seems to me that what you're saying is that's probably the last place that someone's going to get a permit to carry a gun. How is that, regardless of what we think of the policy of that, how is that consistent with Heller's reasoning that the reason the Second Amendment applies a direct personal right is for self-defense?
Well, I'll say a couple of things about that. One, if you go right to history and tradition, the history was to regulate most strenuously in densely populated places. That's what fairs and markets are. So we have history. But we also have a rationale for that history, which is that where there is dense population, there is also the deterrent of lots of people, and there is the availability of law enforcement.
Yeah, because no one's obviously ever been raped, murdered, or robbed in broad daylight in front of other people. This wasn't going to be a share the pain stream, but it's damn near getting there.
In England, the idea was that it was the king's peace, and it was in fact an insult to the king for people to take things into their own hands.
Well, but that's not always true. It depends, obviously, in the jurisdiction and all that, but simply because a place is, well, it's paradoxical that you say a place is a high crime area, but don't worry about it because there are a lot of police around.
Well, and the other thing is that these regulations are all an effort to accommodate the right, to recognize and respect the right of self-defense while regulating it to protect.
Well, according to her, when she just mentioned the king and it was an offense to him for you to defend yourself, apparently you were just supposed to, I don't know, bend over and take that dick until the king could get around to I don't know, pulling it out of you. And that's pretty much the way they're thinking about this when it comes to police. No, you just bend over and fucking take it, and then eventually the police will come draw a chalk outline around your ass and write a fucking report. These fucking people are insane, man. I just the level of mental gymnastics they have to go through to make these points. It would be funny if these weren't the jackasses who were actually making the laws.
The public safety, and in areas where people are packed densely together, as the questioning that just happened displays, the risks of harm from people who...
Yeah, Crow, it would literally look like you were in a fucking snowball fight before the cops got there. Just smile and take it. It'll be okay. It's nothing but the money shot.
Who are packed shoulder to shoulder, all having guns, are much more acute than they are.
Oh, sure, and I can understand, for example, a regulation that says you can't carry a gun into, Giant Stadium, just because a lot of things are going on there, and it may not be safe to have for people to have guns. On the other hand, if the purpose of the Second Amendment is to allow people to protect themselves, that's implicated when you're in a high crime area. It's implicated when you're out in the woods.
Well, I think it is implicated when you're out in the woods. It's just a different set of problems. I mean, you're deserted there, and you can't, and law enforcement is not available to come to your aid if something does happen. But
well, how many muggings take place in the forest?
Well, quite a few, actually. When you are around areas where people think you're defenseless, well, then that's when these sorts of crimes are going to happen. And this is a guy who is supposed to be for the Second Amendment, who is actually damn near making anti-gun arguments for us. And I'm not sure whether he's just tripping over his own argument because he's a very intelligent guy, or these people are just, they've lived their lives so protected from everything that they can't fit into their head that I can't carry a cop in my damn pocket. Yeah. How many people have been raped, robbed, murdered, and everything in Central Park? A fucking lot. It just fucking kills me. Hey, just get a rape whistle. Call 911 on your phone. Get a rape whistle. You don't need shit. I can't. Well, no, this one's apart. You don't need anything that goes bang. Anything with a, red dot on it or anything like that. You don't need anything like that. Just blow your rape whistle and call 911, and maybe the cops will get there in time to draw a really good chalk outline before, I don't know, fucking rigor mortis kicks in. Fucking Christ, man.
If we
how many do you think?
I don't know, but I will tell you that our licensing officer told us that rapes and robberies happen on the deserted bike paths, and that he has some concern about that. So, I mean, I take your point that there is a different risk in the city, but there is also a different public safety consideration, and that is why the licensing officer is meant to take into account not just the risk, but also the population and the availability of law enforcement and all these considerations. I won't say that the risk, I think it's not correct to characterize the risk as atypical. The risk has to be specific to the person. What the cases say is that you can't just say, I'm afraid, because based on facts that are not specific to you. But what Mr. Nash did was convince the licensing officer that his trip to a deserted parking lot every night was sufficient.
What if it's one of these, crime ways, whether it's, a celebrated spate of murders carried out by a particular person? I don't know who that is, the son of Sam or somebody else. Is that a good reason to, is that a atypical reason? Is that a justification? Some random person is going around shooting people. I'd like to have a firearm even though I didn't feel the need for one before.
Well, I think that it would have to be brought home to you in particular, to your route, to your parking lot, to your, your apartment building, but something specific to you rather than it's happening in the world at large. That's what's meant by something non-speculative here.
Could I explore what that means for ordinary law-abiding citizens who feel they need to carry a firearm for self-defense? So I want you to think about people like this, people who work late at night in Manhattan. It might be somebody who cleans offices, it might be a doorman at an apartment, might be a nurse or an orderly, might be somebody who washes dishes. None of these people has a criminal record. They're all law-abiding citizens. They get off work around midnight, maybe even after midnight. They have to commute home by subway, maybe by bus. When they arrive at the subway station or the bus stop, they have to walk some distance through a high-crime area, and they apply for a license, and they say, look, nobody has said, I am going to mug you next Thursday. However, there have been a lot of muggings in this area, and I am scared to death. They do not get licenses. Is that right?
That is, in general, right, yes. If there's nothing particular to them, that's right.
How is that consistent with the core right to self-defense, which is protected by the Second Amendment?
Because the core right to self-defense doesn't, as this court said, doesn't allow for all to be armed for all possible confrontations in all places.
No, it doesn't, but...
And see, that is another reason I say the Heller decision was a fucking punt. It wasn't the 100% victory that it could have been if someone like, I don't know, Clarence Thomas was actually writing that opinion. It should have been sealed right then. It's 100% right to defend yourself with whatever you see fit, firearms, knives, you name it, in any situation. Now, if I'm going to go into a place that will not allow me to have firearms and they have metal detectors there that I have to pass through, well, then sons of bitches should have lockers where I can take my firearm, lock my firearm up very nicely, and then walk through their metal detectors just like everybody else there. And to be honest, unless I am going through metal detectors, I'm fucking carrying. Those little ass stickers on doors with the gun and the slash through it don't mean a whole lot of shit to me, because they damn sure don't mean anything to criminals. Ask all the sons of bitches who have been shot in malls and shopping centers that have those little handy dandy stickers on them. Yeah, he did. And you have to imagine, man, these people have security. They're living in some very prestigious areas. They're not going to fucking Save a Lot like we are. They're not going to Walmart like we are. They're not driving across town without security like we are. It's another reason that I've always said you cannot depend on the Supreme Court to defend our rights. It's a fucking coin toss. Yeah, that would be a kick-ass keychain.
It doesn't mean that there is the right to self-defense for celebrities and state judges and retired police officers, but pretty much not for the kind of ordinary people who have a real felt need to carry a gun to protect themselves.
Well, if that ordinary Mr. Nash had a concern about his parking lot and he got a permit, I think the extra problem in Manhattan is that your hypothetical quite appropriately entailed the subways, entailed public transit, and there are lots of people on the subways even at midnight, as I can say from personal experience, and the particular specter of a lot of armed people in an enclosed space.
There are a lot of armed people on the streets of New York and in the subways late at night right now, aren't there?
I don't know that there are a lot of armed people.
No?
I mean, there are people with illegal guns, if
Yeah,
that's
that's
what
what
you're
I'm
referring
talking
to.
about.
Yeah.
How many illegal guns were seized by the New York Police Department last year? Do you have any idea?
I don't have that number, but I'm sure it's a substantial number.
But the people, all these people with illegal guns, they're on the subway.
I
They're
don't
walking around the streets, but
Now, and see, even that argument's a bunch of horse shit, because a lot of the guns that were seized from so-called criminals were people that were arrested that had a gun on them that had no criminal history, but just the mere fact of them having a gun, they caught a felony charge for it. Just for having the gun. Not that they were threatening anybody, not that they were out committing other crimes. They just had a gun. In some cases, they just had a magazine.
the ordinary, hardworking, law-abiding people I
Let me
mentioned,
look
no,
at something.
they can't be armed.
Well, I think the subways are, when there are problems on the subways, are protected by the transit police, is what happens, because the idea of proliferating arms on the subway is precisely, I think, what terrifies a great many people. The other point is that proliferating guns in a populated area where there is law enforcement jeopardizes law enforcement, because when they come, they now can't tell who's shooting, and the shooting proliferates and accelerates, and in the end, that's why there's a substantial law enforcement interest in not having widespread carrying of guns.
On the standard of particular to them, just to follow up on the other questions, why isn't it good enough to say I live in a violent area and I want to be able to defend myself?
Well, what happens in these license hearings is that a question is asked, what exactly do you mean? Because
Well, the statistics.
it depends on how large an area you describe. You could say, I live in a violent area, and that could be all of New York City, or it could be your particular neighborhood, and the closer it gets to your
Yes,
particular
because New
neighborhood,
York City is
the
a
better
violent
your-
fucking place.
The better your claim is, or your block.
Goddamn moron.
One of the petitioners made an assertion about robberies on his block. I also know that there was a hearing about that, and he evidently did not convince the licensing officer that they were sufficiently recent or relevant or couldn't be dealt with adequately by his own premises license, which he would be entitled to have without any justification or proper cause at all. So what I know happens is that those claims are examined by a licensing officer. Now, this gets to your to questions about discretion and whether that's effectively handled, but
Well, that's the real concern, isn't it, with any constitutional right? If it's the discretion of an individual officer, that seems inconsistent with an objective constitutional right. I mean, what if you're a runner? You say, I run a lot. And as you correctly pointed out earlier, there are a lot of serious violent crimes on running paths. It's a real problem. Is that good enough?
probably. I mean, that's the
And I
counterpart to Nash's claim. But
Probably,
if that's
though.
the question, that is not the way this case was tried. That's not the way this claim was framed. And if the question is, does the system actually operate in the way that we're describing, then this case should be remanded for a hearing to determine whether it does.
And what's the problem with the shall issue regimes from your perspective that exist in many other states, including very populous states, Florida,
The
Illinois?
problem with the shall issue regimes is that they
Let's do something. Hold on, because I think I got something downloaded. Let's do something. Since we're talking
license?
about
Plan to bring your gun to my hometown next time you fly in?
Pack all unloaded firearm and firearm parts in a locked
Now this is John Stossel, in case you don't know who this cat is. And there's two videos we'll look at real fast, just to look at New York gun laws and how they're actually working.
Hard-sided container.
If you call the TSA, they will tell you, put the gun in a locked container and
notify the airline during the ticket counter check-in process.
And yeah, you guys remember that last hearing we did on the TSA, right?
But even if you do this properly, New York authorities will still wreck your life.
I declared my gun, because I always do. I fly in and out all over the U.S. with it.
Patricia Jordan carries her gun for protection. She correctly followed all the TSA procedures when she flew from her home in Georgia to New York City.
It's in the TSA.
Yeah, watch what happens to this chick.
Everything's separate, it's locked.
She was traveling with 3 teenage girls and wanted her gun in
just
her
a
hotel
little bit
room.
where I can talk
I know that
over
if something happens, then I can protect myself.
I was glad that she had brought it just in case something did happen.
On their way home,
Yeah,
Patricia
Stossel
did
couldn't get
everything
his
correctly
carry
again.
permit,
The airline
even though he
counter,
was
she
a
again
public
told the
figure and
agent
everything.
She wanted to check her gun. But this time she was told, wait.
The next thing I know, they're getting ready to arrest me.
For what exactly?
For having a gun. I thought I was going to pass out. I really did.
Yeah.
I have my permit. I'm doing everything I'm supposed to, right?
Because I started freaking out.
She sat there and begged the lady, please don't.
This lady looks like an absolute fucking terrorist, right? Goddamn, she had a gun in New York. She was probably going to murder someone, right? That's what these laws are supposed to stop.
Arrest my mom. Please don't arrest my mom. She's like crying, begging her not to take me.
The police put Patricia in jail and told her, you've committed a felony.
The minimum was 3.5 to 7 years mandatory prison for this.
Another visitor, Avi Wolf, was jailed just for having a gun part, an empty magazine.
There were no bullets. It's just something like this.
It was exactly like that. Instead of a plastic exterior, mine had a little bit of a different make to it, but it was exactly that.
Yeah.
Somebody could
For
have
a
done more
fucking
damage
magazine
to an
in
individual
his
with a
goddamn
$4
luggage going through New York.
Wolf, too, checked with the TSA beforehand. They told him, just declare it to TSA agents at security.
I'm telling them that. Just notification, I have a magazine here. It's empty. There's no bullets. There's no gunpowder. It's, I called TSA before doing it, and this is what they told me to do, was to declare it.
And this dude and that woman, they were just traveling through New York. And yeah, New York wanted to put them in fucking prison.
The next thing I know, they pull me over to the side, and they're all like, do you know what you have in your bag? I'm like, I know what I have in my bag. I told you what I have in my bag. Fast forward about an hour, it was a four Port Authority police officers are there. The chief of LaGuardia Airport is there. They thought they found somebody trying to do 9/11 repeat.
For this?
Literally, for that. They asked me if I had a gun license. Of course, I had a gun license. I'm from Georgia, and everybody there's got a gun license. And they're like, well, sir, you're going to be getting...
Because obviously this guy is a serious fucking threat to the public. I mean, his fucking yarmulke could probably cut somebody's goddamn throat.
Arrested now. I'm like,
The other prisoners couldn't believe why Avi was in jail.
One guy beat up his wife. This other guy is busted with a whole bunch of drugs. She's like, so what did you do? Why are you here? It's like, I got caught at security with an empty magazine.
What'd they say?
Just laughed at it. It's a joke.
Can you imagine this cat in a fucking jail in New York? This dude. In there with rapists, murderers, drug dealers, high-level criminals, and you have this dude locked the fuck up. Yeah, I mean, he probably does have a nuke under his fucking yarmulke. I'm just saying. I mean, he could. I mean, maybe he's Mossad. He's like fucking the Israeli John Wick and everything. Kill you with a fucking pencil. Can't let him have a magazine, unloaded magazine with no firearm. But hey, it's New York.
But it was no joke. Avi and Patricia were released after a day in jail. but they still face that felony charge.
I could barely function. I had to get on like anxiety medicine. I was
Yeah, man, 30 caliber magazine clip. Hold on. Where do I have my 30 caliber magazine clip? Where's that? I know it's somewhere close. Oh, no, that's a real magazine. Yeah, my 30 caliber magazine clips around here somewhere. It's one of the plasma cuts that I did.
throwing up every day.
Months later, New York allowed each to plead guilty to a lesser charge, public disorder. But it cost each $15,000 in legal fees. Why does New York City
$15,000 for trying to do everything right, for trying to follow every law? $15,000. Hey, homeless, what's up, brother? Yeah, $15,000. How in the? I thought this wasn't going to turn into a share the pain stream, but it's fucking getting there.
do this to people? They need to spend a day in jail?
We get through the system as quick as we can.
District Attorney Jack Ryan handles New York Airport gun charges.
We're not going to apologize for enforcing our gun laws. We do enforce them fairly and humanely and as compassionately as we can.
How is it fair and humane to take a woman who is just traveling through New York on her way to another destination, put her little mama ass in jail, and have her spend $15,000 to fight a felony? How, in what fucking world does that work? Yeah, it's anybody getting a carry license in New York is either a multi-million-dollar Hollywood star, a cop, a judge, a public official. It ain't your normal person out on the street just going to fucking work.
Is it a fair system when it costs them $15,000, $17,000 and they spend a day in jail?
It's as fair as we can be under all of those circumstances.
Even in Avi's case? It's an empty piece of plastic.
Whether the magazine is made out of plastic, Kevlar, or metal, I think is immaterial. It's a question of how many bullets it holds. That's why New York has banned them.
Isn't what...
Oh, man. That guy clearly has not been punched in the fucking face enough. Clearly hasn't been punched in the face enough.
Material is whether it held any bullets. It didn't. It was empty.
You can discuss that with the legislature. They didn't make it a crime only if there's bullets in it. They made it a crime.
Patricia had carefully separated her gun from her bullets.
The officer could not even find my bullets in my suitcase. I had to stop and go show her where they were. But yet they said that this was considered a loaded weapon in New York.
Under New York law, if they're together, they're loaded. And so we have prosecuted a number of those cases.
Loaded even if they're not loaded?
If the weapon and the ammunition are together, they're loaded.
Most every week, New York jails someone who innocently travels with a gun, legally licensed in their state.
These are people who are trying to do everything right. They go on the TSA website. They follow.
It makes you kind of think about what the old AFT's doing these days, right? People trying to legally Form 1 suppressors. But hey, even if you try to do everything right, you're still a criminal in the eyes of the government. Yeah, pretty much, Crow. Yeah. You can bet your ass that the ATF and the state of New York have gotten together at some point to make these regulations, along with Moms Demand Action and Giffords Group, Everytown, all these assholes. So you can have your gun in a locked case. You can have your bullets separate from that gun in another compartment. And if it's still in that same area, well, fuck it, it's still loaded. I guess you could beat someone to death with it, or I don't know, throw the fucking bullets at them.
To fly with their gun, they go on the airline website, and they follow the regulations to properly fly with their gun.
And then New York jails them. You're a sadistic bully locking these people up. These aren't threats.
We know they're not threats after we check them out. We do not know who they are when we first talk to them.
Give me a break.
So you have to jail someone for 24 hours, run their background, give them 9 kinds of hell, charge them $15,000 to figure out they're not a threat when they literally weren't committing any crimes in the first place. This is what this chick, we'll go back to the hearing in a minute because we're going to watch one other thing, but this is what this chick is defending.
Prosecutors have discretion. They could be reasonable with these poor people who had no idea that they'd violated New York's strange laws. But New York politicians don't want you to have a gun, so they will put you in jail to send everyone a message.
And that is 100% right. And that's what they're doing, is they're trying to send a message. It's, man, it's so absolutely freaking insane. It's just vile. Let's look at John Stossel real quick again.
What if you want to carry one of these for self-protection? I thought the Supreme Court said you could.
The majority concluded that the right to own a gun belongs to each law-abiding American.
But what does that mean to me in my town? In New York City.
Oh, I'll tell you what it means, John.
Politicians say
Majority of the people want sensible gun restrictions.
sensible restrictions. What does that mean?
I like how they come up with the majority of the people want these so-called sensible restrictions. I'd like to know the majority of people that they're talking to. They must be all those fucking Biden voters out there.
Copies not accepted. I tried to get a gun license. They make it very hard. First, you must fill out this 17-page form. The form says I must promise I know the definition of other weapons like switchblade knife, gravity knife, pilum ballistic knife, metal knuckle knife, a kung fu star. I don't want a kung fu star. I just want...
He got that fucking G.I. Joe Kung Fu grip, baby. Fuck these people.
A gun for safety. People sometimes threaten me because they don't like what I say on TV.
I think that's a common sense.
I think they have too much security now. After this appearance, some said I should be shot in the face. So when I travel around town, I'd like to have the option of protecting myself.
Studies show Americans use guns every day to stop crime.
Guns often...
Whereas they say the CDC can't study gun crime or anything like that, the CDC has statistics on all this stuff. Now, their numbers vary in between 500,000 and like 3 million defensive gun uses a year. Why do we even let these people try to shape this fucking narrative?
Stop crime.
The robber got more than he bargained for.
Turns the tables on a knife-wielding intruder.
Today, laws in every state allow adults to carry a concealed gun. Many fear this would lead to a surge in gun crime, but the opposite happened.
Violent?
What they're talking about, I think, Bacon, is like the Chinese throwing stars. But we are talking about a bunch of idiots trying to define something, so a kung fu fucking star, I guess, makes goddamn sense. Maybe there are a lot of ninja crime in New York that we don't know about. I mean, they're fucking ninjas. They disappear.
Appears to be dropping.
And yet some towns like Chicago, Washington, D.C., New York City make it nearly impossible for people legally to carry a gun. This is 50 pages. Who understands this? It took hours and hours to fill out the forms. We had to call the police department 6 times to clarify what questions meant. Finally, it was done. I have to get this notarized?
You go ahead and sign here, and I will fill in the rest.
Then you have to go in person to police.
Now, you're in a big metal fucking tube with a bunch of people you don't know, and there is a hell of a lot of crime on subways in New York because they know people aren't armed. Would you not want to be armed in that situation to defend yourself? I sure the fuck am going to be. But that's also a reason I've never taken my short fat ass to New York, because fuck that state.
Headquarters. Here, they fingerprinted me, asked me to list reasons why I should be allowed to have a gun, and then they charged me a $430 application fee. They said they'd get back to me.
$430 to apply for the license. Just to apply, and you can still be turned down, and you bet your ass they're keeping that $430 fucking dollars.
At least they were polite. Others tell a different story.
They're rude right from the get-go.
Robert Martinez served in Iraq and Afghanistan.
I have 10 years of military experience.
I think a military vet could keep a handgun in his home for protection, but
It's not so easy.
why do you want a gun permit?
Because I want to be able to protect my family.
Martinez lives in a New York City housing project.
A couple of months ago, a man was beaten to death out in front of my building.
Now, first off, just out of my personal feelings, it's a fucking shame we have a guy who served 10 years in the military living in a goddamn housing project in the first fucking place, while you have useless ass politicians making hundreds of thousands of dollars a year, infringing on your rights. Yeah, shit like that doesn't sit well with me. But maybe it's just me.
All of a sudden, you hear shots go off, and it's like boom, boom, boom.
So he thought he'd just get a gun license, but that turned out to be an ordeal.
They'll have you there at 9 o'clock when they open up at 10, and they'll have you sitting there until almost 3 in the afternoon.
They serviced me within 90 minutes.
Is John Stossel coming here to get a license? It's not really going to be
So
that
for
big.
you, it was 9 in the morning till 2.
Yeah.
And did you get the permit?
No.
Their attitude is that people don't need guns. We're the police.
The police can't get there. You have a better shot at hitting the lottery than getting a cop on your street.
There's so much crime in these places, cops can't even keep up with the fucking calls they get in a single night. Again, this is why they're running around drawing chalk outlines around people. And the Supreme Court has already decided that police have no constitutional mandate to protect you. They are there to draw chalk outlines and solve crimes after crimes have been committed. Why the fuck don't I want a gun?
Exactly at the same time that you get problems.
The process itself was set up to be an ordeal.
Glenn Herman runs this website, which advises people on navigating the regulations.
If you're this expert, I would think it would be easy for you to get people guns.
It's still an ordeal. It's being used as a weapon to deter people from following through the process, which can take as long as a year.
For me, it took 8.5 months. First, they told me I had to return to police headquarters for another in-person interview. This time, they demanded that I prove an accusation against me had been dropped. They said this headline was not enough. I was supposed to produce the original court documents. They also told me I had to document threats against me. Fortunately, I could show them things like this. 52 days later, they sent me a letter rejecting my application for a carry permit. They said I could get a license to keep a gun in my apartment.
He lost his paperwork and can't prove that he served. Are you shitting me? That's absolutely ridiculous. Which, hey, it's the fucking United States government. I mean, my uncle served in Vietnam, and they didn't actually show that he served in Vietnam until a couple of years ago. The man's 76 years old. And they couldn't get that shit right.
But I feel safe in my apartment. I want a permit to carry where I might feel threatened. But I was told, you failed to demonstrate a special need. The license advisor told me I'd applied for the permit the wrong way.
friends of the ruling class, that's who gets it. Everyone else, you're out of luck.
Donald Trump got a permit to carry a gun. So did Howard Stern and Robert De Niro.
It should be done through the cronyism way. Maybe you've done work for someone who knows a senator. That's the approach you make. They will get you in front of a judge, and within 2 to 3 days, you will have your permit.
These individuals can afford to pay for security. My family can't. There's no way in hell I'm going to let this lie.
So yeah, that is New York's permitting system. So let's get back and listen to the hearing some more.
They multiply the number of firearms that are being carried in very densely populated places, and there is a much higher risk, without assuming any ill intent on the part of the carriers of weapons. They greatly proliferate the likelihood that mistakes will be made, fights will break out.
But has that happened in those states? I mean, can you make a comparative judgment? Because it seems like before you impose more restrictions on individual citizens and infringe their constitutional rights based on this theory, you should have to show, well, in those other states that have shall issue regimes, actually there is a lot more accidents, crime, and I don't see any real evidence of that.
Yeah, I think there is a brief from the social scientists that addresses this, but this law has been in place for over 100 years, starting at a time when the law was not as well understood in this area as it is now, and so. It's a little bit anachronistic to talk about before you put this law in place, you should have evidence. But I believe there is evidence about the success that New York has had in keeping keeping gun violence down, that is attributable to the reduced number of guns that are being carried, particularly in these densely populated places. So,
General, one of the things that strikes me about this area is that on the one hand, it seems completely intuitive to me, and I think
my roosters. It's about that time in the morning where they decide just to start busting off for no fucking reason.
Less populated areas, the rural areas of New York versus the cities. I mean, it seems completely intuitive that there should be different gun regimes in New York than in Wyoming. Or that there should be different gun regimes in New York City than in rural counties upstate. But it's a hard thing to match with our notion of constitutional rights generally. I mean, Mr. Clement makes a big point of this in his brief about how we would never really dream of doing that for the First Amendment or other.
Yes, apply the logic that these leftists apply to firearms, apply that same logic to any other product, and that logic does not stand up. I don't see the fucking issue.
Constitutional rights allow that level of local flexibility that you are basically saying we should allow in this context. So I guess I just want to hear you say why you think that is. What justification is there for allowing greater flexibility here?
Well, I think one point is that there is a very wide range of sort of distribution of rural and urban and different kinds of areas, not just across the whole state, but within counties. And so delegating the decision-making with appropriate criteria to somebody who is local, which is what this is. These are local judges in most of the state. They're judges. To make the relevant fact findings, to make the relevant inquiry. This is an interactive process in which these individuals and others are told, I'm not going to lift the restrictions now, but if you come back, if you have more to say about this, feel free to come back. It's an ongoing process. It's one reason why there isn't so much appellate litigation, is that that is what happens.
There's no real appellate litigation because no one can afford to fight the fucking state, you know, bag.
and have it be a clear on-off switch and still take adequate account of, on the one hand, the need for self-defense, and on the other hand, the strong public safety concerns. And that's why I think this system...
I don't think that was Justice Kagan's question.
Oh, I'm sorry.
It was on a broader level, I believe. She can correct me if I'm wrong. The issue is, no other constitutional right do we condition on permitting different jurisdictions to pass different regulations. But do we have any other constitutional right whose exercise in history has been as varied as gun possession and use?
Well, I think that's right, both at the level, the local level, and at the state-to-state level. We have a strong history here of a range of responses from state to state that is based on local conditions and local concerns. And what we have within New York is an effort to recognize we have almost the same range of different kinds of spaces within the state, and this is the effort to accommodate that. And if the history...
Yeah, absolutely, Bacon, yeah.
Conditions and local population density...
If there was no crime out there, no risk to public from criminals, the self-defense aspect of this would go away.
To the highest state court.
Thank you, counsel. Justice Thomas, anything further?
But there are, let's just take, for example, hunting. That's something I think we can agree on. You can't hunt, I'm sure, with a gun in Central Park. But I'm certain that there are places in upstate New York or even in western New York where you can. I don't
Including Rensselaer County, yes.
Yeah. So I think what we're asking is if that you can have that difference for the purpose of hunting specifically, why can't you have a similar tailored approach for Second Amendment based upon if it's density in New York City, if that's a problem, the subway, then you have a different set of concerns in upstate New York.
Well, hunting permits work for particular locations, for particular areas, but it's all one statewide regime. I mean, and so too here, licenses are handled locally. It's not exactly the same, but it's the same model that licensing of handguns to carry a handgun for self-defense is handled locally under a single set of criteria, but with reference to local conditions. I think that's right.
Justice Breyer?
Are we considering here just the upper state New York law? We're not considering New York City, are we?
I don't see any reason to be considering New York City,
Okay,
which
so it's not in the case.
petitioners are not from.
They're not.
See,
Okay,
yeah.
all right. Now, if you're trying to get uniformity, doesn't the First Amendment, isn't it filled with local statutes use the word may, parade permits, event permits? So
Yes.
it's not special. Can you
Correct.
think about...
In the areas where permitting happens, which includes First Amendment areas, it could be parades, it could be solicitation for charity. There are various areas where First Amendment activity is
So it's
subject-
what I'm driving towards, and I thought also there is a brief here, I think it's the social scientist, remember the name of it, which says in instances where, and they do it statistically, they are more liberal in allowing people to carry concealed weapons who are good character people, and there's a greater risk of a crime or harm. Where that happens, there are more deaths.
Yeah, easy access to firearms online or firearms parts has definitely costed me some money.
I believe it is a brief of social scientists, but...
All right, I'll find it.
Yeah.
But do you think it's useful to, were we to have a trial, could we go into that? I mean, I think the great problem would be, fine, let's have some absolute rules, uniform national rules. I'm not sure we have those in the First Amendment, but assume we do. What are they? What are those rules?
Well, I think they would end up being factors that have to be taken into account because the range of situations is.
So their analogy with some of this shit on free speech would be the equivalent of you have to wear a fucking ball gag so you can't talk at all unless the government says you can talk. What fucking world do these people live in?
So different, both on the need side, on the public safety side. So I think it's very hard. In fact, that's one of the things that I think is hard about the suggestion that a sensitive place regime could replace a system like this.
Or if you had a guess on how many concealed carry licenses are given in the area under consideration, upstate New York or outside of New York City, in a given year or around, any way you want to put it, are they in the tens of thousands? Are
Well,
they in
I can't do it statewide. I have statewide estimates, not estimates. I have permits for Rensselaer County and for statewide. It would be possible to get more, but I don't.
Are they rough? What are they?
This is in footnote 10 of our brief. In the 2-year period, 2018 to 2019, in the state, there were approximately 37,800
Okay,
grants.
I get the idea. And if in fact it were remanded, I guess we could go into that in more depth.
That's correct. That's correct. We have the grants. Of course, there are licenses that weren't granted in those years that are still valid, so that doesn't tell you how many licenses there are out there altogether. The thing we had to estimate was the grant rate because we don't have application data. We had to estimate that from other information, but we have the permits.
Justice Alito?
Is it correct that the non-speculative standard applies throughout the state? It applies equally in New York City and in the most rural location in upstate New York?
Well, it has been, the law has been interpreted to mean that, although the experience of granting licenses, or the experience with license applications, is that it is apparently more readily satisfied upstate.
So the individual officers have a degree of discretion.
Well, yes, they're asked, like judges on many issues, they are asked to take into account certain factors. They can be reversed if they took the wrong factors into account or if they failed to take the specified factors into account. It's not unguided discretion, but it is discretion in the sense that...
What guarantees, if any, are there in your regime that a licensing officer is not taking into account improper factors?
I mean, this is a question about the judicial system generally. If he correctly records the factors that he took into account, they write letters or opinions which may or may not fully disclose. One assumes will disclose what they thought was important. When they're not just the papers, but there are the, if he denies a license, he will say why. He has to say why.
We've been presented in your brief and all the other briefs in this case with an enormous amount of history, citations to all sorts of statutes and other sources. Would you be willing to concede that maybe you got a little bit overly enthusiastic in your summary of some of the historical sources that you cited in your brief? I'm going to give you.
We did our best to be accurate in report.
In other words, wouldn't you admit that you're absolutely full of shit?
What we reported, I don't know what you have in mind.
Yeah, well, I'm going to give you an example, which is, it's troubling. I can see how it would slip through. I'm not accusing you personally of anything, but on page 23, you say that in founding era America, legal reference guides advise local officials to, quote, arrest all such persons as in your sight shall ride or go armed. And this is a citation to John Haywood. Manual of the Laws of North Carolina, 1814. So I looked at this manual, and what it actually says is, you shall arrest all such persons as in your sight shall ride or go armed offensively. And somehow that word offensively got dropped from your brief.
I would
think that's an irrelevant word?
I think it would have been better to put it in as an explanation, but I do think it's an irrelevant word because we have substantial authority for the proposition that guns were deemed to be offensive weapons. And that's why we have this dispute about whether saying, I mean, there are different ways of putting it.
So what she's saying is you can't use a gun for defense. They are only offensive weapons. Funny when there are so many defensive gun uses every year. Yeah, pretty much, Crow. Yeah, a well-educated populace. Yeah, we ain't got that no more. 70, 80 years of letting the left in this country have the educational system has pretty well fucking doomed us at this point.
Offensively or with offensive weapons or to the terror of the people, these either describe a separate characterization, a separate feature that not all weapons have, that's my friend's position on this, or they describe the belief that all such weapons are offensive.
Well, I don't want to belabor the point, but of course if any possession of weapons outside the home was illegal, then there would be no need to put in the term offensively, the inclusion of that.
Well, there are many other weapons. Usually there's a list that's, it's not in this particular instruction, but there will be a list of weapons. They were talking about much more than guns, and it was guns that were said over and over again to be offensive.
All right, well, thank you. Thank you.
But that's the explanation. I'm
Justice Sotomayor? Justice Kagan?
You started a thought and then you were taken off someplace else, so I just wanted to allow you to finish the thought.
The funny statement there is this bitch can actually have a thought, which I find offensive to anybody who actually has a brain.
What you said was that there was a reason why a sensitive place regime cannot serve as a replacement, and then you were not given an opportunity to say why. So why?
Well, essentially because there are, it would be very hard in the first instance, and I think also not very acceptable in the to my adversaries on this in the second instance, to specify in advance all the places that ought properly to be understood as sensitive. So it sounds like a very convenient alternative, but for example, we were talking about Times Square on New Year's Eve. Times Square when the theater district, when commerce is in full swing, Times Square almost every night is shoulder-to-shoulder people. So then you end up having a very big difficulty in specifying what all the places are that have the characteristics that should make them sensitive. It has, in principle, it has an attractive quality to it, but in implementation, I think it would be unsuccessful.
Justice Gorsuch?
No further questions, thank you.
Justice Kavanaugh?
No, thank you.
Justice Barrett?
Have one. General Underwood, do you think Heller was rightly decided?
I think there is a lot of support historically and otherwise for it, so I'm quite content to treat it as rightly decided. I think there was an argument on the other side too, but that's true about maybe most of the difficult questions that come before this court. I have no quarrel with Heller.
Do you think that we are bound by the way that we characterized history in that opinion? You know, Mr. Clement has pointed out that in some respects, the way that we treated, say, the Statute of Northampton and is different from the way that you argue that we should interpret that and the follow-on, statutes in the colonies. You argue that we should understand those in some other cases differently than we did in Heller. Are we free to do that?
I think you are, because I think the Heller decision made very clear that it was not deciding anything other than the right to keep firearms in the home.
And that again is why I say Heller was a fucking punt. Yeah, you can have weapons in the home, even though in New York you still have to get a license to keep a weapon in your home. But it did not make clear that you have the right to carry a weapon with you for defense no matter where you were at, because your right to self-defense is not limited to your home.
In the course of arriving at that decision, it necessarily said a lot of other things that led to that decision, but I don't think they are controlling, or I think the opinion itself says we're not trying to do a full exegesis of the whole Second Amendment right, and there's more to be done, and it would be odd and really inconsistent with general practice to treat every sentence or every reference to a historical source as controlling for all time, as distinguished from for the purposes for which it was invoked.
Thank you, General.
Thank you, General. Mr. Fletcher?
Thank you, Mr. Chief Justice, and may it please the court. New York's proper cause requirement is consistent with the...
So this is the New York Rifle and Pistol Club Association. This is their rebuttal to all the bullshit that hag was just slinging.
Second Amendment, because it is firmly grounded in our nation's history and tradition of gun regulation. Now, as Justice Alito said, there's a lot of history floating around this morning, and so I want to be clear that when I say that, I am putting to the side all of the disputed bits about the Statute of Northampton, about the surety laws, and I'm putting to the side laws that restricted concealed carry but did not restrict open carry. And I am focusing on laws that either prohibited or required a showing of good cause to carry a concealable weapon like a pistol. Tennessee enacted one of those laws in 1821. Texas followed in 1871. New Mexico and Arkansas likewise enacted such laws years immediately after the ratification of the 14th Amendment. And over the decades that followed, more than a dozen other states enacted other laws that were at least as restrictive as New York's. Like my friends from New York, I count about 20 laws in total that fit that description. Those laws remain in force in 7 states today, and more than 80 million Americans live under their protection. They are, in short, both traditional and common regulations. I welcome the court's questions, or I'm happy to continue.
How do we determine which states we should look to? You focus a lot on Western states, but the West is different.
I agree, Justice Thomas, and I think there might be reason to be skeptical about a tradition that's only reflected in one state. I think that's a problem for Mr. Clement in relying on some of the cases exclusively from the antebellum South. But the cases that we're relying on come from the South, like the Tennessee, Arkansas, and Texas law I described. West Virginia had a similar law, as did Alabama, New York, Massachusetts, California, Hawaii. The tradition that I am drawing on spans 2 centuries, going back to the Tennessee law, spans 150 years when you broaden it out to many states, and spans all regions, or virtually all regions. So I think that's the sort of tradition that you can look to when defining a national...
Yeah, a lot of the gun laws that the left is pointing to, restrictions on rights, were all racist gun laws. You gotta love it that a lot of people don't get called out on that kind of shit. But hey, we're talking about people who believe that the state has the overall power and not the individual. So yeah, they just completely breeze over the origins of a lot of these old gun laws.
National tradition of gun regulation.
I mean, what is the appropriate analysis? I mean, you sort of, we I think generally don't reinvent the wheel. I mean, the first thing I would look to in answering this question is not the statute of Northampton, it's Heller. And Heller has gone through all this stuff. And obviously in a somewhat different context, although that's part of the debate, self-defense at home, this is different. But I still think that you have to begin with Heller and its recognition that the Second Amendment, it has its own limitations, but it is to be interpreted the same way you'd interpret other provisions of the Constitution. And I wonder what your best answer is.
And I'm still looking for the limitations in the Second Amendment. I haven't found any yet. It's pretty simple. It ends off with a very simple clause: the right of the people to keep and bear arms shall not be infringed. It didn't say the right of the militia. It didn't say the right of whoever the fuck government approves of. It said the right of the people to keep and bear arms. So I'm still looking for the restrictions area in that.
To the point that Mr. Clement makes in his brief, which is that, for example, if you're asserting a claim to confront the witnesses against you under the Constitution, you don't have to say, I've got a special reason. This is why I think it's important to my defense. The Constitution gives you that right, and if someone's going to take it away from you, they have to justify it. You don't have to say when you're looking for a permit to speak on a street corner or whatever, that your speech is particularly important. So why do you have to show, in this case, convince somebody that you're entitled to exercise your Second Amendment right?
So let me start with the general question and then get to that specific point from Mr. Clement. As to the general question about Heller, we agree completely that the court ought to apply the method from Heller, which we, like I think all the parties take to be, look to the text, history, and tradition of the Second Amendment right. And we're applying that now to a somewhat different issue with the benefit of somewhat broader materials. Now, as to the question about why do you have to have a showing of need, I think the problem with Mr. Clement's formulation is that it assumes the conclusion. If you had a right, the Second Amendment conferred a right to carry around a weapon for possible self-defense just because an individual wants to have one available, then obviously you couldn't take away that right or make it contingent upon a discretionary determination. But the whole question is whether the Second Amendment right to keep and bear arms confers that right to have a pistol with you for self-defense, even absent a showing of demonstrated need.
I'm not sure that's right. I mean, you would, regardless of what the right is, it would be surprising to have it depend upon a permit system. You can say that the right is limited in a particular way, just as First Amendment rights are limited, but the idea that you need a license to exercise, I think is unusual in the context of the Bill of Rights.
So I agree with that, but I think I heard even Mr. Clement in response to a question from Justice Kavanaugh say he doesn't have a quarrel with licensing regimes in general. And I think what that is one illustration of is that
this guy right here, I think I kind of had it wrong. This guy is arguing for the state side of it, not the National Rifle and Pistol Association. I'm not sure why they had this second lawyer come in to argue for the state.
Second Amendment has a distinct history and tradition, and that the way to be faithful to the Second Amendment is to be faithful to that history and tradition and not to draw analogies to other rights with their own histories and traditions.
Well, there's licensing and there's licensing. Maybe it's one thing to say, we need to check, make sure you don't have a criminal record, make sure that all the other things you can check on, but not that we assume you don't have a right to exercise your
So I guess
it's hard to say it without saying it, with exercise your right. You've got to show us that you do.
So we would ask that question by looking to the history and tradition of the Second Amendment. And in Tennessee in 1821, you couldn't carry a pistol at all. In Texas in 1871, you had to have a showing of need.
So just because it was unconstitutional then it should be enforced now. If people were informed about their rights back then and had fought these things back then, we'd be in a little bit better position now, I think.
If you were going to carry a pistol. And that showing of need was actually much less favorable than the New York regime. In Texas, in West Virginia, and in Alabama, in those laws that we cite, need to carry a firearm was a need that you had to show when you were prosecuted for violating the law. It was essentially a self-defense requirement, and you had to persuade a jury in a criminal trial that you had an immediate pressing need to be carrying the gun when you were carrying it. The laws, of which New York's is one, but by no means the only example, that began to become more prevalent in the 20th century, said, we're going to make that determination of need ex ante. We're going to require the showing of good cause. New York has done that for a century. I'm sorry, Justice Kavanaugh.
This might be a level of generality issue, but I think Mr. Clement responded to some of what you're saying on history and tradition by saying you have to look at carry laws more generally. And there was open carry traditions in a lot of those states. And so that I think he followed up by saying, so open carry is one option, shall carry permit regimes for concealed carry another option, but what you can't have is no open carry and simply a may issue discretionary regime that will, in practice, he said, the right. So can you respond to that?
Yeah, I meant to be taking that into account in the account of history that I'm giving you. So the Tennessee laws refer specifically to carry publicly or privately. Texas, the same story. If I were here defending a regime that just prohibited concealed carry and allowed open carry, I would have many, many, many more states. But I'm focused on just this type of law, and even there, our submission is there's a substantial history and tradition of that kind of regulation. It's not the sort of outlier that the court confronted in Heller and McDonald.
Yeah, we had a history of slavery back then too. So just because something was done in the past doesn't make it right now. These people are morons.
And if I could speak to, Mr. Clement has spoken some about the case law from the 19th century and has suggested that laws like these were struck down. And with all respect, that's not correct. The cases that he is relying on are primarily dicta. The two cases he has that actually struck down laws, or I'm sorry, the three cases that he has that actually struck down laws are the Nunn decision from Georgia, which struck down a law that was banned even the keeping of pistols. The court did say in dicta that open carry was required, but the law was actually much more restrictive than that. The Andrews case that he relies on and that Heller relies on as well is actually more helpful to us because the court upheld a prohibition on the carrying of belt or pocket pistols. And it prohibited a ban on revolvers only because the court construed that ban to be so broad that it would prohibit even carrying it around your house. And in the very next sentence, the court said, but of course the legislature, if it wanted to, could regulate the carrying of that firearm publicly.
So what we're saying in this case is courts have always been screwing around with our rights to defend ourselves, and that somehow makes it right. Again, courts upheld slavery, they upheld segregation. Those things weren't right just because the courts upheld them. It goes to show you all these jackasses in these black robes have done more to screw this country than anything.
And then when you turn to laws like the one we have here, which include some sort of self-defense exception, either ex ante or ex post, the trend in the cases is in favor of upholding their constitutionality. We've cited about 6 decisions from the 1800s and the early 1900s, including the Duke and English cases from Texas, the Isaiah case from Alabama, the Haley and Fife cases from Arkansas, and the Workman case from West Virginia, all of which upheld those laws. And Mr. Clement's answer to those decisions is that they rested on the erroneous understanding that the Second Amendment or its state equivalents protected only the right to use arms in the militia. But that is not what those cases say.
Well, Bacon, that's what New York is basically doing with their permitting scheme. I mean, you actually had to have a premises permit to have a gun in your own home. Doesn't mean a lot of people don't have guns in their own home, but if you ever had contact with law enforcement and they came to your home and figured out you had a firearm, well, guess what? Your ass is going to fucking jail for having legal property in your own home.
They do not stop by saying that the defendants were militiamen and so had no rights. The Texas cases in particular, in Duke and English, say that the law makes all necessary allowances for self-defense by including the type of exception we described earlier. And so our submission is that that body of case law that New York law carries forward is part of our nation's history and tradition of firearms regulation, and that New York ought to be allowed to continue to make the choice that it has made. Now, we understand.
Yes, the country has had a long history and tradition of trampling the rights of individuals, which has led us to this point where we live under the regime of a state who has a say-so in every aspect of our lives. There's nothing that you do in a day where the government doesn't have some say-so in it. Even if you go take a piss, they basically have regulations on how much water your toilet can flush. The pure insanity of this is what gets me. The fact that we live in a world where the state is so large where they get to tell you what you can and can't do in every aspect of your life. There's nothing in your house that doesn't have some sort of government approval or government regulation on it. Whether it's the construction materials it's made out of, the size of it, how much power it uses, you name it.
And there's Mr. Clement's argument that other states have made other choices. Justice Alito made powerful points about how some individuals have a powerful claim to have a gun for self-defense. But the question before the court is, of all of the different approaches to these difficult issues that states and other jurisdictions have taken over our nation's history, is this one that the Second Amendment takes off the table? And our submission is that when it's an option that New York has, and other states have had for a century or more, traces as far back as some of the laws that I've been discussing into our nation's history, that's an option that is consistent with our tradition of gun regulation and is an option that ought to be available to the states.
Justice Thomas? Justice Breyer? Justice Alito?
Is it correct that the Sullivan Law was an innovation when it was adopted?
It was relatively new. I think the Sullivan Law was 1911. The licensing requirement at issue here was 1913. I think Massachusetts had done something similar in 1906. Hawaii did its as well in 1913, and we view those as lineal descendants and, in fact, improvements upon the sort of Texas laws, which made you prove self-defense at the back end rather than giving you a chance to demonstrate it up front.
There's a debate about the impetus for the enactment of
Yeah, the come and take. Yeah. That's basically what C&T Designs is built around, the whole come and take. That C&T is a play off of a couple of things, one of which is the come and take. I don't understand how more people don't take the time to inform themselves about some of this shit.
the Sullivan Law, is there not? There's those who argue, and they cite support for this interpretation that a major reason for the enactment of the Sullivan Law was the belief that certain disfavored groups, members of labor unions, blacks and Italians, were carrying guns, and they were dangerous people, and they wanted them to stay.
There have been those arguments made, and there's certainly evidence that those sentiments existed in New York at the time. I have not seen things that persuade me that those were the impetus for the Sullivan Law, and to the extent that that was a question, I think the fact that similar laws have been enacted and maintained, not just in New York, and not just at that moment in time, but in a number of different states throughout the country, throughout large swaths of our nation's history, is a good reason to believe that this is not just prejudice, that this is a legitimate regulation.
I think one more question about the major point that you've made this morning, which is that there are scattered statutes, local ordinances, judicial decisions from various points in the 19th century, extending into the 20th century, the early 20th century with the Sullivan Law, and the other laws that you mentioned that are inconsistent with Mr. Clement's statement. But what does that show about the original understanding of the right that is protected by the Second Amendment? would we be receptive to arguments like that if we were interpreting, let's say, the First Amendment or the Confrontation Clause of the Sixth Amendment? Would we say, well, you can find a lot of state laws and state court decisions from the 19th century, early 20th century that are inconsistent with a claim that is made based on the original meaning of a provision of the Bill of Rights, and that shows that's what that was understood to mean at the time.
Well, Justice Alito, I think Heller was receptive to those types of arguments and conducted a review of history through the 20th century, and rightly so. I think it's not unusual to look to the nation's tradition to understand the meaning of constitutional rights. I think that's especially appropriate here for a couple of reasons. One is that I think everyone agrees that the right codified in the Second Amendment is a right that is subject to some reasonable regulations, and in deciding what regulations are reasonable, we think the fact that they've been prevalent throughout our history is a good sign that they are. We think that's especially so because of a point that this court made in McDonald, which is that throughout the nation's history, this is a right that's been recognized and codified in state constitutions as well. It's not something that people were not aware of. And so the fact that this type of regulation coexisted for so long with that understanding, we think is a particularly strong indication of its consistency.
Well, Heller, and I will stop after this, Heller cited decisions going into the 19th century as confirmation of what it had already concluded based on text and history at or before the time of the adoption of the Second Amendment. It said this is what it was understood to mean at the time, and it's further evidence that this is what this right was understood to mean because it kept being reaffirmed by decisions that came after. But I find it hard to understand how later decisions and statutes, particularly when you start to get into the late 19th century and the early 20th century, can be used as a substitute for evidence about what the right was understood to mean in 1791 or 1868 if you think that's the relevant date.
So you're certainly right about the way that Heller looked to decisions on its core holding of does the Second Amendment protect only a militia-focused right or an individual right. But when Heller turned to the question presented here, which is what sorts of regulations are consistent with the right that it was recognizing, I think it's fairly read to extend the analysis into the 20th century for the reason that Justice Kagan identified, that it validated as presumptively lawful felon in possession requirements, bans on the possession of firearms by the mentally ill that date to much later than the 19th century.
Thank you.
Justice Sotomayor?
What do you do with Heller and its recognition of categories of exclusion? Mentally ill, felons, domestic violence, presumably, although it didn't mention it. Can any of those ever pass scrutiny on their face?
I don't know. I think the lesson from Heller, though, is that you don't need to apply strict scrutiny or any other level of scrutiny because those are the types of regulations that are validated by our nation's history and tradition of gun regulations. And so we would take that lesson from Heller as exemplifying the proper mode of analysis and apply it here as well.
So what do you do with the view, Mr. Clement's view, that the essence that Heller says is that you do have some sort of right outside of the home to guns for self-defense. So how do you finish what you think that right is? Or how do you...
Again, why would my right to self-defense and my right to carry tools to defend myself stop at my front fucking door? Yeah, and even with the militia end of this, it was the right of the people to keep and bear arms. It wasn't the right of the militia. Basically stating that your right to keep and bear arms was not connected to service in the militia.
Describe it.
So we don't quarrel at all with the notion that the Second Amendment has something to say outside the home. Our submission is just that to understand how it applies outside the home, one has to look to the history and tradition of regulations. And what we've tried to argue in our brief and this morning is that there is a substantial history and tradition of the regulation of the public carrying of concealable weapons, including pistols, because of the dangers that they present. Regulations of that type, of which New York's is one, are consistent with the right recognized in the
How
Second
about,
Amendment.
let's go to the extreme. There's no exception for a good cause. There's no exception for no exceptions whatsoever. No rifles for hunting, nothing. Outside the home, you can't possess any kind of ammunition-driven weapon.
Yeah.
Where would we be with that?
I think that is a type of regulation that fortunately no state has today, and I don't think there's any historical precedent for. I don't think you could make this sort of argument for that
So
sort of
give me the limiting principle of what regulations and how far they can go that don't achieve that.
Right. So I think, like Mr. Clement, it's going to be difficult for me to give you definitive answers because, in our view, this is an inquiry that has to be driven by history and tradition, and that requires a careful examination of history and tradition. But let me give you a couple of guideposts. I think there is a tradition of laws like the Tennessee law that I alluded to earlier and others that prohibit the carrying of concealable weapons without any exception for self-defense or any good cause exception like the one that you have in the New York law. So we think, and Judge Bybee for the en banc Ninth Circuit concluded after an exhaustive historical analysis, that those types of regulations are consistent with the Second Amendment. But I acknowledge that that's a tougher historical case to make than the case that you can make with respect to laws like New York's that include self-defense exceptions.
Thank you.
Justice Kagan?
Mr. Fletcher, I think I probably should have asked General Underwood this question, but I forgot, so here you are. And the United States also has law enforcement officers, even though they operate differently from sort of the cop on the beat. But I'm just wondering if there is anything that you can say, any evidence that you can share. Are there studies? Is there information about how this actually affects how getting rid of this regime in the way Mr. Clement would want this court to do, how it affects policing, how it affects the ability of police officers to keep the streets safe, and how it affects their own safety. Is there information about that? Are there studies?
There are. I think the best place I can point you to for studies are some of the amicus briefs, including the social scientist brief that Justice Breyer discussed with my colleague, General Underwood. In terms of sort of the United States' perspective specifically, I don't have any sort of quantifiable statistics. What I can tell you is that we do share the concern behind the New York law, which is the concern that having more guns on the street does complicate and increase the danger inherent in citizen law enforcement encounters. We do think that's a real concern, and it's one of a number of real concerns that are reflected in the law that New York has.
Do police officers stop people in the same way in notwithstanding whether it's a New York regime or a more permissive regime?
I apologize. I don't have studies on that. All that I can give you is my own sense that if I were a police officer, I would certainly think prominently in my mind about what are the odds that the person that I'm stopping or approaching on the middle of the highway, late at night, is likely to be armed, and the licensing regime in the state is going to be an important factor in the risk that that's the situation.
Thank you.
Justice Gorsuch?
Mr. Fletcher, in your brief, you that the New York law passes both the text and history approach and intermediate scrutiny. Should we apply that? And I guess I'd like to pose the same question to you that I did to Mr. Clement, and that is, what is the appropriate test between those two or others? The lower courts seem very divided over how to approach Second Amendment questions. Some apply the text and history approach to the challenge before them. Others say, yes, text and history is appropriate, but we're not going to extend the Heller right until and unless the court first does so through its own text and history analysis. We're not going to do it ourselves. Others have applied intermediate scrutiny. Others have applied what might be described as a watered-down version of intermediate scrutiny. And some have suggested strict scrutiny or some modification of it should apply. I'd just be grateful for your thoughts.
I appreciate the question, Justice Gorsuch, and I think our view is that courts ought to follow what we understand to be the lesson from Heller, which is that you start with text, history, and tradition, and when those sources provide you an answer one way or the other, either that the law is valid or that it's invalid, you end there, and that's the end of the inquiry. We take that approach to be consistent with the approach described by Justice Kavanaugh in his dissent in Heller 2. I think the one place where we might differ from him a little bit is that we think there may come a point, especially as when courts confront new regulations, where history gives out, where it's not possible to draw those historical analogies anymore. And at that point, our suggestion is that the way to be faithful to history and tradition is to look to the broader method that you find in that history and tradition, and the method that we find in a half dozen or so cases from the mid-1800s that we cite is to ask whether the law is a reasonable regulation. And as we explain in our brief, we think that the modern judicial method that is most faithful to that approach is a form of intermediate scrutiny.
Thank you.
Justice Kavanaugh?
Thank you. Mr. Fletcher, appreciate your focus.
See, these guys always argue for the intermediate scrutiny because they know that they can slip some shit through versus a strict scrutiny, which they know that their gun laws won't stand up to. And in my humble opinion, anytime we're dealing with a constitutionally defined right, it ought to be held under strict scrutiny at every turn. There should never be any intermediate scrutiny or less than intermediate scrutiny when it comes to our constitutional rights. Thinking about gag gifting a CA compliant rifle, that's a dick move. Funny, but that's a dick move.
On history and tradition, and want to explore that and get your thoughts on one thing. As you say, there's a tradition, and it exists to the present day, of permitting regimes. And so the issue before us will have effects, but it's a narrow legal issue of shall issue versus may issue, and it'll have substantial effects. But there is a tradition of permitting regimes. But how do we think about, do you think, kind of a separate tradition that the Chief Justice and others have referred to in our constitutional law of concern about too much discretion in exercise of authority over constitutional rights, and the too much discretion can lead to all sorts of problems, as our history shows. So you've got the tradition of permitting, but how do we think about, fold in just a general concern about too much discretion?
So I appreciate that concern, and I think here's how I would think about it. First, I would say there is a substantial history of discretion in this particular area, starting with in the Texas and West Virginia type regimes that I talked about now, moving into permitting officers. I think that's inherent in any system. If you say a permit is going to be conditioned upon a showing that you have a genuine, specific need for self-defense, then someone's got to make the decision about whether or not you've made that showing. New York has decided it's best to do that by delegating the authority to local officers, local judges who are most familiar with local conditions. I do appreciate the concern about discretion, and I think if the court were to conclude that some sort of good cause, sort of self-defense based exception is required, then the court might conclude that some more predictable or stringent or prescriptive guidelines are required, that you can't have that much discretion if the court concludes that that sort of good cause exception is actually constitutionally required.
Thank you. Appreciate it.
Justice Barrett? Thank you, counsel. Rebuttal, Mr. Clement?
Thank you, Mr. Chief Justice. Just a few quick points in rebuttal. First of all, I want to highlight that when the government was asked for its interest behind this permitting regime, it said that if it went to a different regime, it would multiply the number of firearms in circulation. In a country with the Second Amendment as a fundamental right, simply having more firearms cannot be a problem and can't be a government interest just to put a cap on the number of firearms. And that just underscores how completely non-tailored this law is. It might be well-tailored to keeping the number of handguns down, but it's not well-tailored to identifying people who pose a particular risk or anything else, because it deprives a typical New Yorker of their right to carry for self-defense. Second point I want to make is just about population density. There's been a lot of discussion about that, but it's very much a double-edged sword, because when there's a population density, that's an awful lot of people who all have Second Amendment rights. And so you can't just simply say we're not going to have Second Amendment rights in the areas where there's dense population. And I would say here, experience does tell you a lot. By my count, 7 of the...
Okay, here's something for these idiots. The original or first draft of the Virginia Constitution, and I'm looking at it right now on, where am I at? Let me roll up here real quick. Hell, I'll throw it in the damn chat. So this is the first draft, I think, of the Virginia Constitution, written by Thomas Jefferson. If you want to know how these guys feel about arms, where am I at? One line in this Constitution says, "No free man shall ever be debarred the use of arms." I'm pretty damn sure that's cut and dry, is it not? It's a single sentence. It's got a period at the end. It's pretty damn simple, cut and dry. That's the way these guys felt about us having arms. No free man shall ever be debarred the use of arms. Why in the hell these lawyers can't bring up the historical letters that our founders wrote in support of the Second Amendment and laying out their thoughts about the Second Amendment? I have no idea why I haven't seen a single hearing yet where these historical documents were brought into play. And yeah, I mean, they mean men, women, everybody.
10 largest cities in America measured by population are in shall-issue jurisdictions. And I've mentioned them, cities like Phoenix, Chicago, Houston. These are large cities where it hasn't been a problem. If you want to look at the empirical evidence, and I know, Justice Breyer, you asked about this, please also look at the English brief on the top side, because it's a very rigorous statistical analysis that shows that as a matter of actually doing statistics right, there's no difference here. And what the only difference you really see is that people who have a handgun for self-defense end up with a better outcome. They're not shot. They're not made victims. But the English brief, I think, is really worth taking a look at. I want to say a quick word just about permitting. There may be limiting permitting in other contexts, like parade permitting, but I'm not aware of any context whatsoever where in order to get a permit, you have to show that you have a particularly good need to exercise your constitutional right. And I think that is the absolute central defect with New York's regime here. I want to say a quick word about the history that my friend from the Solicitor General's office emphasized. It's telling that his first example is Tennessee. If you look at the Heller decision, Tennessee is a problematic state in terms of its history. That Tennessee Supreme Court first came out with the IMET decision, which the majority opinion in Heller criticized. It then came out with the Simpson decision and the Andrews decision, both of which protected Second Amendment rights, and the majority opinion in Heller praised those decisions at the same time that it criticized AMET. So to the extent there was an 1821 statute, I would put it in the same box as the AMET decision. Texas, which is their next example, and their only other 19th century example, if I heard my friend correctly, is even more problematic to rely on because Texas had a specific constitutional amendment that was similar to the English Bill of Rights but different from the Second Amendment that allowed the legislature to put specific restrictions on the right. So relying on 1871 Texas is highly problematic from a historical perspective, and that just leaves them with 20th century examples, which we concede, but by that point, the collective rights view of the Second Amendment was everywhere. Let me finish just by saying there's absolutely no need for a remand here. There are interesting statistics that could be developed, but none of them are relevant to the two central defects in this regime. First, that in order to exercise a constitutional right that New York is willing to concede extends outside the home, you have to show that you have an atypical need to exercise the right that distinguishes you from the general community. That describes a privilege. It does not describe a constitutional right. That is a sufficient basis to invalidate the law, but then there's the discretion. And the discretion here has real-world costs. If you want to look at it, look at the amicus brief in our support by the Bronx public defenders and other public defenders. The cost of this kind of discretion is that people are charged with violent crimes, even though they have no prior record, just because they're trying to exercise their constitutional right to self-defense. And if you want to know how this impacts policing, one of the way essentially making everybody in New York City a presumptive person who is unlawfully carrying is that leads to stopping and frisking everybody. The framers, I think, had a different vision of the Fourth Amendment and the Second Amendment, and that is that individuals get to make their decision about whether or not they want to carry a firearm outside the home for self-defense. In 43 states, people are able to do that. It doesn't mean everybody ends up carrying, and it doesn't mean that those 43 states have any more problems with violent crimes or anything else than the 6 or 7 jurisdictions that don't honor the text, the history of the Second Amendment, and Heller. Thank you, Your Honors.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday next at 10 o'clock.
So, hope everybody had fun with that one. But like I said, I brought that up and just wanted to listen to it and just kind of hang out because Stephen Breyer is in this hearing, and this new Supreme Court justice that Biden has nominated is someone who is just like Stephen Breyer. Matter of fact, she clerked for him. So any questions on how she will deal with any kind of firearms cases can really be answered by who she has surrounded herself with. So we pretty well know how she's going to act. And Stephen Breyer, well, he doesn't give a shit about firearms rights. Yeah, they're all natural rights, Bacon. It's being understood as natural rights. Every creature has a right to defend itself. Bears don't leave their fucking claws whenever they leave a cave. And I realize bears don't really live all the time in caves, but yeah, they don't leave their claws at home whenever they go out to go do something. Lions don't pull their fucking teeth out whenever they go about doing anything other than hunting. It's a natural right inherent to every living creature on this planet to have a defense mechanism. Being humans and being designed as we are, we have tools that we can use to defend ourselves. Those tools should not be restricted, much like we don't restrict the right of any other animal to defend themselves. Looking at some other quotes from our founding fathers, in a letter Thomas Jefferson wrote, he quoted another source, but he found the need to put this into his letter. And this quotation states that laws that forbid the carrying of arms disarm only those who are neither inclined nor determined to commit crimes. Such laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicides. For an unarmed man may be attacked with greater confidence than an armed one. Pretty well throws that into a nice little bucket, doesn't it? And let's see, I'm working off of 2 different sites here. Matter of fact, let me throw this one up. Now, what I will say is off of this site, what I do is I will pull whatever they are trying to quote and research it to ensure that it's coming from a reliable source. So, like this source, the first one I put up, this is actually a government website. It's the foundersarchives.gov. And they've got a lot of the founders' letters and stuff on this site. And this is a historic site. All of these letters have been researched and proven to be 100% correct. So, yeah, there's that. And again, why in the hell can these people that are trying to argue this shit in court not do the research and actually pull the founders' supporting documents into these arguments? That's something I haven't seen yet, and I don't understand why these folks can't do that. So if we come down here, let's look at this one. Yeah, Let me copy that over and insert something real quick just to find a second source on it. So this goes back to the Founders Archives. Cartwright, and since I don't want to read this whole fucking letter, let's Control F it and search. Hold on, what am I looking at? Okay, so here it is. This is in one of his Thomas Jefferson's letters. Representative, freely and equally chosen, that is their right and duty to be armed at all, or to be at all times armed. Pretty specific on that one. Let me go back to the start of that. This is a pretty long fucking thing. Let's just say, we established, however, some, although not all its important principles, the constitutions of most of our states assert that all power is inherent in the people and that they may exercise it by themselves in all cases to which they link themselves competent, as in electing their functionaries, executive and legislative, and deciding by jury of themselves both fact and law, in all judiciary cases in which any fact involved, or they may act by representatives freely and equally chosen, that it is their right and duty to at all times be armed. Again, another quote that is pretty well established and very easily understood. And that was a letter from Thomas Jefferson to John Cartwright in 1824. There was another specific quote I was looking for from one of the guys. And we've all pretty much heard this one. They that give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. That's another quote from a man, Ben Franklin, the pimp. To disarm the people is the most effectual way to enslave them. That was George Mason. And this is another good one. Before a standing army can rule, the people must be disarmed. As they are in almost every country in Europe, the supreme power in America cannot enforce unjust laws by the sword because the whole body of the people are armed and constitute a force superior to any brand of regular troops. Well, we're kind of crossed that now. And the right of the people to keep and bear arms shall not be infringed. A well-regulated militia composed of the body of the people, trained in arms, is the best and most natural defense of a free country. I'm still looking. There was another quote where one of the founders basically, he said it very bluntly, that the people should have every implement of war, no matter how dangerous. And then Samuel Adams, the Constitution shall never be construed to prevent the people of the United States, who are peaceable citizens, from keeping their own arms. I still wonder why in the hell none of these get brought up in support of what our founders meant for the Second Amendment. So I have to find some of those quotes later. But yeah, all these letters are out there that were written back and forth. Federalist Papers, anti-Federalist Papers, a bunch of basically op-eds that were written to the papers from our founders in support of the Second Amendment and what it meant. But somehow these jackasses can't find these historic documents that supported what the founders meant by the Second Amendment. And yeah, those guys, our founders, were absolute radicals. These are people that put their lives and their fortunes on the line to tell a king with the biggest, baddest army on the planet to go eat a bag of dicks because they were done with his shit. And somehow we have gone from that to people in black robes who want to restrict every freedom we have. Yeah, I mean, these people, man, Bacon, they will disarm anybody. Firearms rights are a civil, a natural right. And it's been argued many times by other people, and argued by myself. How is a woman of especially a smaller stature going to defend herself against some guy that's 6'2" and pushing 220 when she's 5'4" and a $110? There are very few women who could defend themselves in that situation. hand to hand. However, a firearm, well, old big boy getting shot in the dick will take all the fight out of him. Just saying, pull old Clint Smith quote, shoot him in the dick. They will no longer want to fight with you. There's a reason that we've talked about firearms as being the equalizer for a very long time. Let's pull up something else handy dandy. Now let's roll this one out. Now this is the original District versus Heller oral arguments.
Now, Supreme Court arguments in a case challenging the constitutionality of the handgun ban in the District of Columbia. The last time the court addressed the gun issue was in 1939. The justices allowed extra time, so this argument is a little more than an hour and a half.
We will hear argument today in case...
So we won't make it through all of this, but we'll listen to some of it. Hell, I still got a few beers and a few smokes left.
Mr. Chief Justice, and may it please the court. The Second Amendment was a direct response to concern over Article 1, Section 8 of the Constitution, which gave the new National Congress the surprising, perhaps even the shocking power to organize, arm, and presumably disarm the state militias. What is at issue this morning is the scope and nature of the individual right protected by the resulting amendment. And the first text to consider is the phrase protecting a right to keep and bear arms. In the debates over the Second Amendment, every person who used the phrase bear arms used it to refer to the use of arms in connection with militia service. And when Madison introduced the amendment in the first Congress, he exactly equated the phrase bearing arms with, quote, rendering military service. We know this from the inclusion in his draft of a clause exempting those with religious scruples. His clause says, the right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. And even if the language of keeping and bearing arms were ambiguous, the amendment's first clause confirms that the right is militia related.
If you're right, Mr. Dellinger, it's certainly an odd way in the Second Amendment to phrase the operative provision. If it is limited to state militias, why would they say the right of the people? In other words, why wouldn't they say state militias have the right to keep arms?
Because it is the right of the people.
And the phrase the militia were really in sync with each other. You will see references in the debates of the Federalist Farmer uses the phrase, the people are the militia, the militia are the people.
If that's right, doesn't that cut against you if the militia included all the people?
So, yeah, that proves the point. The militia was made out of the people, but it was the people's right to own arms. I'm not sure why people have so much trouble with that premise.
Doesn't the preamble that you rely on not really write much at all? It includes all the people.
Yes, I do believe it includes all the people in the sense of Verdugo Riquidez, all those who are part of the polity. What defines the amendment is the scope and nature of the right that the people have. It is a right to participate in the common defense, and you have a right invocable in court if a federal regulation interferes with your right to train for or whatever the militia has established. So that's
the concerns, Mr. Dellinger, of the framers.
Yeah, and that's the honest question. And some of this is who were the people, and the founders' letters all supported that the people were the citizens of the United States. again, I don't see why the founders supporting documents for the Second Amendment were never brought into any of these cases. It makes no sense to me. The only thing that I can think of really when it comes to that is one, the lawyers arguing for the Second Amendment are inept, and two, the lawyers arguing against the Second Amendment want to focus on just that first line of the militia, and there's no way in hell they want to go look at the founders' letters that state who the militia is, who the people are, and their belief that all citizens should be able to be armed at all times.
Was not to establish a practice of amending the Constitution and its important provisions. And it seems to me that there is an interpretation of the Second Amendment differing from that of the district court and in Miller, and not advanced particularly in the red brief, but that conforms the two clauses and in effect delinks them. The first clause, I submit, can be read consistently with the purpose I've indicated of simply reaffirming the existence and the importance of the militia clauses. Those were very important clauses, as you've indicated there in Article 1 and Article 2. And so, in effect, the amendment says we reaffirm the right.
Yeah, I think they're missing a lot of things on purpose, Anthony. Because if my ass can find this, and I'm just a lowly little welder, know nothing peon, why can these supposed learned people not find it? When I'm looking at historical government websites that document these things and have those documents on hand, it seems to me that more people should be able to find these, especially if you are the ones responsible for arguing for our rights. Having those other documents or finding those other documents, you would think would be a pretty big fucking priority. But what the hell do I know?
To have militia, we've established it. But in addition, there is a right to bear arms. Could you comment on that?
Yes.
This makes them. It doesn't. I think you're quite right in the brief to say that the preface shouldn't be extraneous. It's not extraneous. The Constitution reaffirms, the Bill of Rights reaffirms several principles: the right of the people to peaceably assemble, the right to be secure in their homes. The 10th Amendment reaffirms the right. And this is simply a reaffirmation of the militia clause.
Justice Kennedy, I think any interpretation that delinks the two clauses as if they were dealing with related but nonetheless different subject matters has that to count against it. And what you don't see in the debates over the Second Amendment are references to, in those debates, the use of weapons for personal purposes. What you see is a clause that literally transposes to this: because a well-regulated militia is necessary to the security of a free state, the right of the people to keep and bear arms shall not be.
Well, the subject
infringed.
is arms in both clauses, as I've suggested. It's a common subject, and they're closely related.
I think, as this court unanimously held in Miller, or at least noted in Miller, I'll leave aside the debate over home, the court unanimously said in Miller that the Second Amendment must be interpreted in light of its obvious purpose to ensure the continuation and render possible the effectiveness of the military forces.
I don't see how there's any contradiction between reading the second clause as a personal guarantee.
Losing Scalia was a serious hit to the Supreme Court. He actually he punted on this decision in Heller. But he was a pretty sharp cat when it came to our rights. And again, why these justices can't find these damn letters when they're supposed to be deciding these cases, I'll never understand that either.
And reading the first one as assuring the existence of a militia, not necessarily a state-managed militia, because the militia that resisted the British was not state-managed. But why isn't it perfectly plausible, indeed reasonable, to assume that since the framers knew that the way militias were destroyed by tyrants in the past was not by passing a law against militias, but by taking away the people's weapons. That was the way militias were destroyed. The two clauses go together.
Yeah, Anthony, I do believe him waking or not waking up with a pillow over his face was a tad bit suspicious, you might say. Like maybe he got Arkansided. But again, that's just my humble opinion.
Together beautifully. Since we need a militia, the right of the people to keep and bear arms shall not be infringed.
Yes, but once you assume that the clause is designed to protect the militia, surely it's the militia that decides whether personal possession is necessary. I mean, Miller, what makes no sense is for Miller to require the arm to be militia related if the right is not. And
I've got to go dig up because the documents are there. Basically, the written arguments for Miller. I've got to dig that up and do a show on it one time. Yeah, well, yeah, you're right. Yeah, pillow over your face, dirt on the Clintons. Yeah, you know.
Key phrase is bear arms.
Well, do you think the clause is the second clause, the operative clause, is related to something other than the militia?
No, I think the second clause, the phrase "keep and bear arms," when bear arms is referred to in a military context. That is so that even if you left aside,
it had nothing to do with the concern of this remote settler to defend himself and his family against hostile Indian tribes and outlaws, wolves and bears and grizzlies and things like that.
that is not the discourse that is part of the Second Amendment. And when you read the debates, the congressional debates, the only use of the phrase "keep and bear arms" is a military phrase, and that is how it's used otherwise. Now,
Blackstone thought it was important. He thought the right of self-defense was inherent, and the framers were devoted to Blackstone. Joseph Story, the first commentator on the Constitution and a member of this court, thought it was a personal guarantee.
But when Blackstone speaks of the personal guarantee, he describes it as one of the use of weapons, a common law right. And if we're constitutionalizing the Blackstonian common law right, he speaks of a right that is subject to due restrictions and applies to, quote, such weapons, such as are allowed by law. So Blackstone builds in the kind of reasonableness of the...
That's a complete fucking perversion of what Blackstone was saying in his legal texts. Again, the amount of mental gymnastics these people have to do to try to fit their argument into this is mind-boggling.
The regulation that the District of Columbia has. Now,
that may be true, but that concedes your main point that there is an individual right and gets to the separate question of whether the regulations at issue here are reasonable.
I don't dispute, Mr. Chief Justice, that the Second Amendment is positive law that a litigant can invoke in court. If a state were to decide after recent events that it couldn't rely upon the federal government in natural disasters and wanted to have a state-only militia, it wanted to have everybody trained in the use of a weapon, a federal law that interfered with that would be a law that could be challenged in court by an individual.
Okay, here's another argument of mine. If the federal government had any right to regulate firearms within the states, why did they use the Interstate Commerce Clause to base all of these gun laws on? Because every gun regulation, every gun law that the federal government puts in isn't based on a clause in the Constitution that says the federal government can regulate firearms. It's based on the Interstate Commerce Clause saying that firearms crime negatively affects commerce in between the states, so the government has the right to regulate it. Why would the government just not outright be able to write laws without including the Interstate Commerce Clause if they had the right to regulate firearms inside the states?
I mean, I think the
Mr.
yes.
Gelder, short of that, and just to get your position clear, short of reactivating state militias, on your reading, does the Second Amendment have any effect today as a restraint on legislation?
It would, Justice Ginsburg, if the state had a militia and had attributes of the militia contrary to a federal law, and if it didn't.
But it doesn't, as far as I know.
As far as I know today, it doesn't. But I'm not, and the respondents make that argument that the amendment is without a use, but you don't make up a new.
Yeah, Crow, that's exactly what Texas said with their suppressor laws. Texas said that these suppressors will be made inside of Texas, sold inside of Texas. They will not be distributed to other states. So the federal government has no power to regulate them. And of course, the government is challenging that. And it will go to the Supreme Court, and we'll see where the Supreme Court rules on that. There was a case in the 1930 something that actually came to a situation where a guy grew more wheat than the government allowed him to grow, and he fed his cattle with it, made his bread out of it, and all that. And the government said that they had the right to regulate what he did because, get this, if he wasn't participating in interstate commerce, he was negatively affecting interstate commerce by depriving other states of his business, so they had the right to regulate it. And that same argument will come around to Texas suppressors. They will say that the base parts for the suppressors traveled in interstate commerce, so they have the right to regulate it. Or that since these suppressors aren't being sold across state lines, they are negatively affecting interstate commerce, so they have the right to regulate it. That's where they'll go, because let's face it, we're dealing with a regulatory state right now that thinks they have all the power.
Whose prohibitions aren't being violated. I mean,
your argument is that its purpose was to prevent the disarming of the organized militia. Isn't that correct?
That is correct.
And if that was the purpose, then how could the framers of the Second Amendment have thought that it would achieve that purpose? Because Congress has virtual plenary power over the militia under the militia clauses.
That is because I think, Justice Alito, that those who wanted to retake state authority over the militia didn't get everything they wanted. Madison actually did this somewhat reluctantly and wanted to maintain national control.
They got nothing at all. Not everything they wanted. They got nothing at all, so long as it was up to the federal government to regulate the militia and to assure that they were armed. The federal government could disband the state militias.
Yes, but
so what was the function served by the Second Amendment as far as the militia is concerned?
Yeah, if the federal government had complete control over who could have arms, what sense does the Second Amendment make in the first place? Because the government, much like Blackstone was talking about, the government could just say, well, we don't necessarily have to disband the militia. We just take all your guns, so you're left with your dicks in your hands and you can't do anything when we come to do what we want to do, making the Second Amendment useless. That makes no sense. That's a little like going to a boxing match, and the referees are against you, and they basically tell you that you are going to have to get punched in the face for the whole match and you can't fight back, and Mike Tyson is going to knock your fucking head off and you can't do anything about it. You know, does that make sense?
It is by no means clear that the federal government could abolish the state militia. It may be presupposed by the Article 1, Section 8, Clauses 15 and 16, and by the Second Amendment that the states may have a militia. That issue has been left open as to whether you could do that, and it can be called into federal service, but only in particular circumstances. Now, I think the better argument for the other side, if there is to be a militia relatedness, aspect of the Second Amendment, as we think clear from all of its terms, then Heller's proposed...
Hey, Crow, that's why you just hit that shit raw, dog. Don't even worry about it.
...preservation or efficiency of a militia, and therefore the case is over. Now,
But your reading of the militia clause specifically reserves certain rights to the states by its terms. And as I understand your reading, you would be saying the Second Amendment was designed to take away or expand upon the rights that are reserved, rather than simply guaranteeing what rights were understood to be implicit in the Constitution itself.
I'm not sure I followed the question exactly, but...
Alex, you may not encourage it, but I definitely do. It's about time we started to question these social contracts, so to speak.
Very important right that ensured that they kept arms, but it wasn't listed in the rights that were reserved in the militia clause.
The debate over the militia clause, what is shocking about the militia clauses, is that this is a new national government that for the first time has the power to create a standing army of professionals. The militia were people who came from the people themselves, put down their weapons of trade. The states were devoted to the idea of their militia of volunteers. And of all the powers granted to the federal government, one of the most surprising was to say that Congress shall have the power to organize, arm, and discipline the militia, and to, even though the officers could be appointed by the state, the discipline had to be according to Congress. And this caused a tremendous negative reaction to the proposed Constitution.
The Second Amendment doesn't repeal that. You don't take the position that Congress no longer has the power to organize, arm, and discipline the militia, do you? So it was supplementing it. And my question is that the question before us is, how and to what extent did it supplement it? And in my view, it supplemented it by saying there's a general right to bear arms quite without reference to the militia either way.
It restricted, in our view, the authority of the federal government to interfere with the arming of the militia by the states. And the word that was caused the most focus was to arm, and that is to disarm. Now, what I think is happening is that two different rights are being put together. One was the textual right to protect the militia. I think the better argument for the other side, from Mr. Heller, is that the amendment's purpose is militia protected, but it was over-inclusive in the way that several of you have suggested, and that is that, as the court below said, preserving the individual right, presumably to have guns for personal use, was the best way to ensure that the militia could serve when called.
Now, when in that day, our founders decided that they were going to make a stand against said king, they didn't have the weapons to arm a complete army. That is why you had people that had fully operational warships that our government enlisted to basically be their navy. It is why they had towns that had cannons that they enlisted to be their artillery. All of those weapons were in private hands. Our founders completely understood the individual right to own arms, all arms.
But that right, this right of personal liberty, the Blackstonian right, is an unregulated right to whatever arm, wherever kept, however you want to store it, and for the purposes an individual decides. That is a libertarian ideal. It's not the text of the Second Amendment, which is expressly about the security of the state. It's about well-regulated militias, not unregulated individual license, as this
What you are saying is that the individual has a right to challenge a federal law, which in effect would disarm the militia and make it impossible for the militia to perform those functions that militias function. Isn't that the nub of what you're saying?
Yes, that is correct. Okay. And if the court were to embrace...
Mr. Dellinger, to what extent do you think the similar provisions in state constitutions that were adopted more or less at the same time are relevant to our inquiry?
I think they're highly...
Fucking John Paul Stevens. This guy was an absolute damn statist. 'Twas not a sad day when he was no longer on the court, much like Justice Ginsburg.
relevant to your inquiry because now 42 states have adopted constitutional provisions.
Well, I'm not talking about those.
You're talking about at the time.
I'm talking about the contemporaneous actions of the states before or at the time of the adoption of the Second Amendment.
I think that the state amendments are generally written in different terms. If you're going to protect the kind of right that is being spoken of here, different from the militia right, the plain language to do it would be Congress or the state shall pass no law abridging the right of any person to possess weapons for personal use, and that's not the right that is created here. One of the troublesome
It literally says the right of the people to keep and bear arms shall not be infringed. That's very, very simple. I'm pretty sure my 5-year-old could read that, and as long as I gave her a definition of infringed, she could get that. It is only when you get someone who goes to law school and can argue over the definition of is that you get someone who can argue over the definition of or what it means when it says the right of the people to keep and bear arms shall not be infringed. Doesn't say the right of the militia. Doesn't say the right of those that the government sees fit. It doesn't say they have the right until the government decides they don't have the right. It states they have the right and it shall not be infringed.
aspects of viewing this as a right of personal use is that is the kind of fundamental liberty interest that would create a real potential for disruption. Once you unmoor it from or untether it from its connection to the protection of the state militia, you have the kind of right that could easily be restrictions on state and local governments.
Well, there's no question that the English struggled with how to work this. You couldn't conceal the gun, but you also couldn't carry it, but you had a right to have it. Let me ask you this. Do you think the Second Amendment is more restrictive or more expansive of the right than the English Bill of Rights in 1689?
I think it doesn't address the same subject matter as the English Bill of Rights. I think it's related to the use of weapons as part of the civic duty of participating in the common defense, and it's
I think that would be more restrictive.
That could well be the answer.
Well, isn't it more restrictive in the sense that the English Bill of Rights was a guarantee against the Crown, and it did not preclude Parliament
that's
passing a statute that would regulate and perhaps limit. There is some guarantee against what Congress can do.
Parliament could regulate, and Blackstone appears to approve of precisely the kinds of regulations here. Now,
Blackstone didn't approve of those regulations. He merely acknowledged that at that time in England, they had those regulations. That is very different than saying he approved of said regulations. You're seriously conflating some shit here, buddy. How should I put this delicately enough? Again, this is another guy who has not been punched in the face enough.
what we have
to the rights of Protestants.
This is correct.
And it was suitable to their conditions and as allowed by law. So it was a group right, and it was much more limited.
I think that is.
As I recall, the legislation against Scottish Highlanders and against Roman Catholics did use the term forbade them to keep and bear arms. And they weren't just talking about their joining militias. They were talking about whether they could have arms.
Well, the different kind of right that you're talking about, to take this to the question of what the standard ought to be for applying this, even if this extended beyond a militia-based right. If it did, it sounds more like a part of an expansive public or an expansive personal liberty right. And if it is, I think you ought to consider the effect on the 42 states who've been getting along fine with state constitutional provisions that do expressly protect an individual right of weapons for personal use, but in those states they've adopted a reasonableness standard that has allowed them to sustain sensible regulation of dangerous weapons. And
what is reasonable about a total ban on possession?
What is reasonable about a total ban on possession is that it's a ban only on the possession of one kind of weapon, of handguns. It's been considered especially dangerous.
So if you have a law that prohibits the possession of books, it's all right if you allow the possession of newspapers?
No, it's not, and the difference is quite clear. There's no limit to the public discourse. If there is an individual right to guns for personal use, it's to carry out a purpose like protecting the home. You could not, for example, say that no one may have more than 50 books. But a law that said no one may possess more than 50 guns would in fact be, I think, quite reasonable.
The regulation at issue here is not one that goes to the number of guns. It goes to the specific type. And I understood your argument to be in your brief that because rifles and shotguns are not banned to the same extent as handguns, it's all right to ban handguns.
That is correct, because there's no showing in this case that rifles and handguns are not fully satisfactory to carry out the purposes. And what the court below says about the elimination of this.
The purposes of what?
I'm sorry?
You said there's no showing that rifles and handguns. I think you meant rifles.
Well, yes, I'm sorry. The rifles and, yes, Justice Kennedy.
Is necessary for the purpose of what? What is the purpose?
The purpose, now, if we're shifting, and if we assume for a moment, arguendo, that you believe this is a right unconnected to the militia, then the purpose would be, say, defense of the home. And where the government here, where the correct standard has been applied, which is where a state or the district has carefully balanced the considerations of gun ownership and public safety, has eliminated one weapon. The court below has an absolutist standard that cannot be sustained. The court below says once it is determined that handguns are, quote, arms, unquote, referred to in the Second Amendment, it is not open to the district to ban them. And that doesn't promote the security of a free state.
But wasn't there a leeway for some weapon prohibition? Let me ask you in relation to the states that do have guarantees of the right to possess a weapon at home. Do some of those states say there are certain kinds of guns that you can't have, like machine guns?
Yes. And what the opinion below would do instead would...
The funny thing about her argument right there is the original challenge to the 1934 NFA came down to whether or not a gun would be useful in military service or not. And it had to do with a short-barreled shotgun. And the court found that the short-barreled shotgun would not be useful in military service, so therefore the restriction on the 34 NFA would stand. So in other words, if the dude had been caught with a belt-fed fucking MG42, which didn't exist at the time, I don't think, but if he had been caught with a machine gun, then that would have been found to be useful in military service, and the 1934 NFA would have been shot down. So this whole argument over civilians having machine guns, well, that wasn't the original reason the NFA got upheld. In fact, if the guy had been caught with a damn machine gun, it would have been found to be useful in military service, and the 34 NFA would have been shot down. So the Hughes Amendment in 86 was absolute horseshit, which just like the NFA is absolute horseshit, and the 68 Gun Control Act was horseshit, and the 86 was supposed to be the Gun Owners Protection Act was absolute bullshit, and bullshit and bullshit and bullshit and bullshit and bullshit. Did I mention bullshit yet?
It's hard to see on the opinion below why machine guns or armor-piercing bullets or other dangerous weapons wouldn't be categorically protected.
Could you go back? Those states, if I could just have one following on Justice Ginsburg quick. Do those states, Justice Ginsburg asked, distinguish among weapons? State constitutional provisions do not do so.
No, it's not in the state constitutional provision. It is in their reasonable application. And here, the question is, how has the balance been struck? The district allows law-abiding citizens to have functioning firearms in the home. From the time it was introduced in 1976, it has been the consistent position that you're entitled to have a functioning firearm. At issue is the one type of weapon that...
Let's come back to your description of the opinion below as allowing armor-piercing bullets and machine guns. I didn't read it that way. I thought the opinion below said that it had to be the kind of weapon that was common for the people. That is common for the people to have. And I don't know that a lot of people have machine guns.
Yeah, a lot of people do have machine guns. There are probably, well, I think last time I checked, there are 500, there are almost 600,000 transferable machine guns in the United States. And there would be more had it not been for the 86 Hughes Amendment, which shut down the new production of machine guns. Now, those are transferables. Non-transferable post-dealer sample machine guns, there are hundreds of thousands of those. And again, there would be more if not for said regulation. Come on, man. Yeah, you can do a search. I mean, the NFA, all those items are documented. I can't remember the numbers for Alabama. There was something like fucking 80,000 transferable machine guns inside Alabama alone. So yeah, rookie numbers. We need to bring that up a little bit. But hey, we're still there. That's another thing that pisses me off about this is this whole in common usage shit that they came up with in Heller. Again, that's why I call it a punt. They didn't run that shit into the end zone like they should have.
I think
or bullets, I think that's quite unusual. Well, but having a pistol is not unusual.
The number of machine guns, I believe, is in excess of 100,000.
Yeah, try over 500,000. You fuck nuts. Again, maybe that's why I'm not on the Supreme Court. I couldn't not call him out on that.
That are out there now.
How many people in the country?
Well, they're 300 million, but whether that's common or not, but
I don't think
it's the court protects weapons suitable for military use that are lineal dependent. I don't know why an improved bullet wouldn't be covered unless you adopt the kind of reasonableness standard that we suggest, where you look to the fact that, and some people think machine guns are more dangerous than handguns. They shoot a lot of people at once, but a handgun is concealable and movable. It can be taken into schools, into buses, and
this guy's a fucking king dingling of goddamn mental yoga, the way he stretches this shit around. Because he's at the same time, he's making the fucking argument that machine guns, yeah, well, you can't conceal them, so they should be okay. But hey, this handgun, it's concealable, so it shouldn't be okay. Okay. I'll take a machine gun over that fucking Glock any day of the damn week. Where the hell do I sign up?
government office buildings, and that's the particular danger it poses in a densely populated urban area.
Well, yeah, I'm not sure that it's accurate to say the opinion below allowed those. The law that the court below was confronted with was a total ban. So that was the only law they considered. If the district passes a ban on machine guns or whatever, then that law would be considered by the court and perhaps would be upheld as reasonable. But the only law they had before them was a total ban.
Or a law on the carrying of concealed weapons, which would include pistols.
Let me fight back on the notion that it's a total ban. It's not as if every kind of weapon is useful.
Are you allowed to carry the weapons that are allowed? I read the carry clause to apply without qualification. So while you might be able to have a shotgun in the home, you can't carry it to get there.
No, you can with a proper license. The district has made it clear that there is no doubt that it interprets its laws to allow a functioning gun. And to say that something is a total ban when you eliminate one particular kind of weapon would apply to a machine gun if it were or came into common use.
But even if you have a rifle or shotgun in your home, doesn't the code prevent you from loading it and unlocking it, except when it's being used for lawful recreational purposes within the District of Columbia? So even if you have the gun under this code provision, it doesn't seem as if you could use it for the defense of your home.
That is not the city's position, and we have no dispute with the other side on the point of what the right answer should be. It is a universal or near universal rule of criminal law that there's a self-defense exception. It goes without saying. We have no argument whatsoever with the notion that you may load and have a weapon ready when you need to use it for self-defense. I'm going to reserve the remainder of my time for rebuttal.
Why don't you remain, Mr. Dellinger? We'll make sure you have.
Yes.
Because I did interrupt Justice Breyer.
Yes.
I just wondered if you could say in a minute, one possibility is that the amendment gives nothing more than a right to the state to raise a militia. A second possibility is that it gives an individual right to a person, but for the purpose of allowing people to have guns.
Okay. Here's something.
Island.
Now, we are going to listen to someone with the same intellect as a lot of these people who are trying to make these jumps about the Second Amendment. And this is something I shall share in other streams. But this is Mr. Hank Johnson, a congressman from Georgia. And, well, we're going to go through one of Mr. Hank Johnson's most famous moments.
That at its widest level is what, 12 miles from shore to shore?
Now, he is talking about the island of Guam.
And at its smallest level, or smallest location, it's 7 miles between one shore and the other. Is that correct?
I don't have the exact dimensions, but to your point, sir, I think Guam is a small island.
Very small island, and about 24 miles, if I recall, long. So 24 miles long, about 7 miles wide at the least widest place on the island, and about 12 miles wide on the widest.
Yes, this guy is in the House of Representatives to this day. He is a lawmaker. He is a lawyer by trade, which is what made me think about this particular clip. Hang on to your brains, because your intelligence are about to get fucking raped.
Part of the island. And I don't know how many square miles that is.
Length times width, motherfucker. Length times width. Area. You can estimate it real easy, you dumb motherfucker. Just saying.
You happen to know?
I don't have that figure, sir. I can certainly supply it to you if you'd like.
Yeah, my fear is that the whole island will become so overly populated that it will tip over and capsize.
Yes, this dumb motherfucker in a congressional hearing just said that he thought if we put more Marines on the island of Guam, that the entire island would tip over and capsize. This is the level of intelligence you are dealing with for our lawmakers, and these people appoint Supreme Court. Well, not him particularly, but the people in the Senate actually appoint Supreme Court justices. So that's how we end up with people who can't fucking read the Second Amendment. I will say this admiral fields this question or this statement way better than I could have composed myself.
We don't anticipate that. The Guam population, I think, currently about 175,000, and again, with 8,000 Marines and their families, it's an addition of about 25,000 more into the population.
That dude is a fucking boss for being able to handle that question the way he did. I, on the other hand, knowing me, probably the first thing out of my mouth would have been, are you fucking joking? Because if you're serious, you obviously need some very serious help. Because you're a fucking moron of absolutely monumental proportions. And I don't know how you survived fucking puberty. And the fact that you're a lawyer is absolutely goddamn terrifying. Good thing you're in Congress, because if you were a lawyer, hope to God you're not a defense lawyer. And every actual person being charged would hope to God that you are the prosecution, because goddamn, you're a fucking moron. All right, back to Supreme Court.
To form a militia. Assume the second. If assume the second, I want to respond, unless you have done so fully already, to what was the Chief Justice's question of why.
And remember, one of the reasons I even started tonight listening to this shit was because we're looking at a new Supreme Court justice who is going to take Stephen Beyer's place, who actually clerked for this guy and learned from him and is further left than Stephen Beyer. And I was going to watch all this shit tonight and listen to it again anyway, and why not do it and torture you fine gentlemen at the same time? Share the love, share the pain.
On the second assumption, this ban on handguns, not the other part, of the District of Columbia, a total ban. Why is that a reasonable regulation viewed in terms of the purposes as I described them?
It's a reasonable regulation for two kinds of reasons. First, the amendment speaks of a well-regulated militia. Perhaps it's the case that having everybody have whatever gun they want of whatever kind would advance a well-regulated militia, but perhaps not. But in any event,
he's well trained, doesn't it?
When you have
doesn't well regulated mean well trained? It doesn't mean massively regulated.
Well, every phrase of the amendment, like well-regulated, security of the state, is something different than a libertarian right. Here you have, I think, on this, particularly on a facial challenge, there's no showing that rifles and shotguns are not fully available for all of the purposes of defense. There is no indication that the district militia is an entity that needs individuals to have their own handguns. I mean, there's a step that is missing here. The well-regulated militia is not necessarily about everyone having a gun. A militia may decide to be organized that way, in which case you would have a different notion. But here, I think when you come down to apply this case, if you look at about 5 factors, that other weapons are allowed, important regulatory interest of these particularly dangerous weapons is clearly a significant regulatory and important regulatory interest. In 2 respects, this is removed from the core of the amendment. Even if it is not limited to militia service, even the court below, no one doubts that that was, as the court below said, the most salient objective. So this is in the penumbra or the periphery, not the core. It was undoubtedly aimed principally, if not exclusively, at national legislation which displaced the laws in all of the states, rural as well as urban. Here you've got local legislation responsive to local needs, and this is local legislation in the seat of the government, where Congress, which was created in order to protect the security of the national government, and where it would be extraordinary to assume that this is the one place, if you're not going to incorporate it, the one area in the United States where no government, free of the strictures of the Second Amendment, could control dangerous weapons.
Thank you, Mr. Dellinger. General Clement.
Mr. Chief Justice, and may it please the court.
Let me look at something real quick. Oh, shit, I can't really see it. Yeah, I'm just playing at this point.
The Second Amendment to the Constitution, as its name indicates, guarantees an individual right that does not depend on eligibility for or service in
sort of
the militia.
preliminary question. Do you think it has the same meaning that it would have if it had omitted the introductory clause referring to militia?
I don't think so, Justice Stevens, because we don't take the position that the preamble plays no role in interpreting the amendment, and we would point to this court's decision in Miller, for example, as an example of where the preamble can play a role in determining the scope.
So you think some weight should be given to the clause? And also, the other question I wanted to ask you, does the right to keep and bear arms define 1 or 2 rights?
Oh, I suppose it probably does define 2 rights that are closely
There's a right to keep arms and a right to bear arms.
I think that's the better view, and a number of state courts that have interpreted analogous provisions have distinguished between the 2 rights and looked at them differently. And obviously the term keep is a word that I think is something of an embarrassment for an effort to try to imbue every term in the operative text with an exclusively military connotation, because that is not one that really has an exclusive military connotation. And as Justice Scalia pointed out, keep was precisely the word that authorities used in statutes designed specifically to disarm individuals.
But it doesn't mean all. It doesn't mean keep. On your reading, at least if it's consistent with Miller, keep and bear some arms, but not all arms.
Oh, absolutely, Justice Ginsburg. And just, to give you a clear example, we were in a position that the kind of plastic guns or guns that are specifically designed to evade metal detectors that are prohibited by federal law are not arms within the meaning of the Second Amendment and are not protected at all.
Oh, fucking Christ. Where is it? Where is it? It's around here somewhere. I know I got it. So these idiots think that a polymer gun such as this can somehow evade metal detectors and be functional. Never mind the fact that they have to have metal rails, springs, pins, the ammunition is metallic cartridges. The barrel is metal. The slide is metal. Big ass spring. Does anybody out there know of a functioning firearm capable of firing a projectile that is going to kill somebody that is completely plastic, non-metallic, or like a ceramic, or well, no, the Liberator still has metallic parts and still uses a metallic cartridge. This mythical fucking unicorn these assholes use to come up with some of this shit is damn near baffling to me. Even if it was caseless ammunition, if you went with damn Kraut space magic with caseless ammunition, the projectile is still metal and metallic. The barrel is still metallic. There are still metallic springs, lifters, shit like that. And what kills me is these people who know jack shit about firearms are still bringing this shit up. It's like they watch Die Hard and, well, what was it? The second Die Hard. Oh yeah, it can pass through metal detectors and it costs more than you make in a month and yada yada. Yeah, it fucking doesn't exist.
In a way, we would say that you should analyze that provision of federal law, as those are not even arms within the provisions of the Second Amendment. I think to make the same argument about machine guns would be a much more difficult argument, to say the least, given that they are the standard issue weapon for today's armed forces and the state organized militia.
In your view, this amendment had nothing to do with the right of people living in the wilderness to protect themselves, despite maybe an attempt by the federal government, which is what the Second Amendment applies to take away their weapons?
Oh, Justice Kennedy, I wouldn't say that it has no application there. As I say, I think the term arms, especially if Miller is going to continue to be the law, is influenced by the preamble. But the way we would look at it...
I agree that Miller is consistent with what you've just said, but it seems to me Miller, which kind of ends abruptly as an opinion writing anyway, is just insufficient to describe the interest that must have been foremost in the framers' mind when they were concerned about guns being taken away from the people who need it for their defense.
Well, Justice Kennedy, we would analyze it this way, which is we would say that probably the thing that was foremost in the framers' mind was a concern that the militia not be disarmed such that it would be maintained as a viable option to the standing army. But especially when you remember, as Justice Alito pointed out, that the Constitution in Article 1, Section 8, Clauses 15 and 16, the militia clauses, as unamended, gave the federal authorities virtually plenary authority to deal with the organization and regulation of the militia. The most obvious way that you could protect the militia...
Plenary authority, not plenary authority.
Except for that which is reserved in...
Who appoints the officers?
Yeah, no, absolutely. There is something reserved in Clause 16. But let me just say, if the Second Amendment had the meaning that the District of Columbia ascribes to it, one would certainly think that James Madison, when he proposed the Second Amendment, would have proposed it as an amendment to Article 1, Section 8, Clause 16. He didn't. He proposed it as an amendment to Article 1, Section 9, which encapsulates the individual rights to be free from bills of attainder and ex post facto clauses.
Do you think he was guided at all by the contemporaneous provisions in state constitutions?
I'm sure he was influenced by that, though I think, honestly...
How many of them protected an individual right? Just two, right?
I think the Pennsylvania and Vermont are the ones that most obviously...
And the others quite clearly went in the other direction, did they not?
Those other constitutions explicitly limited the power of government. There were two that actually defined the power of the individual. What right listed in the Constitution that is enumerated in the Constitution is separate from an individual right? Everything in the Constitution was limiting the government. It wasn't granting people rights. It was limiting what the government could do with those rights.
I don't know about quite clearly. The textual indication in the state amendments
Cat
that
killing
probably
me.
most obviously goes in the other direction is the phrase, keep and bear arms for the common defense. And of course, there was a proposal during the debate over the Second Amendment to add exactly those words to the Second Amendment, and that proposal was defeated, which does...
There was also a proposal to make it clear there was an individual right, which was also rejected.
I'm sorry, Justice Stevens, which aspect of that did you have in mind?
The Pennsylvania proposal.
Oh, but I don't think that ever made it to the floor of the House or the Senate that I'm aware of. And I think that this happened at the actual Senate floor. There was a proposal to add the words...
Yeah, my wife's cat has taken up with me for some reason. And apparently he likes being on YouTube.
Expressions of the right in English law, including the Bill of Rights, 1689?
I do, Justice Kennedy, and I think in that regard it is telling that, there are a variety of provisions in our Bill of Rights that were borrowed from the English Bill of Rights. Two very principal ones are the right to petition the government and the right to keep and bear arms. I don't think it's...
Showing my pussy off again.
If we're going back to the English Bill of Rights, it was always understood to be subject to the control and limitation and restriction of Parliament. I don't think there's any doubt about that. And that's what we're talking about here, a legislative restriction.
Well, Justice Ginsburg, I think you could say
That's
the same
you.
thing for every provision of the English Bill of Rights. And obviously, when those were translated over to our system, you had to make adjustments.
But isn't there one difference? Not every provision of the English Bill of Rights had an express reference to permission by law, which is a reference to parliamentary authority. So that there was a peculiar recognition of parliamentary legislative authority on this subject.
That's exactly right, Justice Souter. And the way I counted it, I only found 3 provisions in the English Bill of Rights that had a comparable reference to Parliament. And
This provision had the additional limitation to suitable to their conditions, and a large number of people were not permitted to have arms.
Again, that is also true and is also...
Yeah, that large number of people that weren't permitted to have arms, you fucking moron, we called slaves at that particular time. And believe it or not, in some instances, even those slaves could have arms. They were there to keep the other slaves in line. So those were the people that actually had to get permission from the government at the time to own said arms. And again, nobody mentions the letters from the founders that laid out their case for the Second Amendment, which was to make a stand against any power, foreign or domestic, that would seek to take our freedoms.
Relatively unique to this amendment. And if I get to the point in the argument where I talk about why we think that something less than strict scrutiny is appropriate, I think I would point precisely to those elements of the English Bill of Rights as being relevant. But what I was about to say is I think what is highly relevant in considering the threshold question of whether there's an individual right here at all is that the parallel provisions in the English Bill of Rights that were borrowed over included the right to petition and the right to keep and bear arms. Both of those appear with specific parallel references to the people. They are both rights that are given to the people. And as this court has made clear in Verdugo-Urquidez, that's a reference that appears throughout the Bill of Rights as a reference to the entire citizenry.
May I go back to another point which is to the same point, and that is consistent with your emphasis on the people, was your emphasis a moment ago on the distinction between keeping and bearing arms. The keep part sounds in your mind, at least, to speak of an individual right, not necessarily limited by the exigencies of military service. My question is, if that is correct, and keep should be read as, in effect, an independent guarantee, then what is served by the phrase "and bear"? In other words, if the people can keep them, and they have them there for use in the militia as well as to hunt deer, why do we have to have a further reference in there to a...
I'm still also missing this hunting clause in the Second Amendment. I haven't been able to find it yet. I've read it quite a few times. Militia necessary for a free state, yada yada, right of the people to keep and bear arms. I ain't found shit about hunting in that little amendment there that we call the Second Amendment to the Constitution. And that amendment came in and was argued over very strenuously because people weren't going to sign on to the Constitution if there was not a guarantee that the government could not take their arms. Yeah, brother, I'll turn it up.
A right to bear as well as to keep arms. And my point is, it sounds to me as though keep and bear forms one phrase rather than two, but I want to know what your answer is to that.
The way I would read it, Justice Souter, is that keep is really talking about private possession in the home. And the way that I would look at it is in order to exercise, for example, an opportunity to hunt, that you would need to bear the arms as well. And I would point you, I think it's a useful point.
But wait a minute, you're not saying that if somebody goes hunting deer, he is bearing arms, or are you?
I would say that, and so would Madison and so would Jefferson, I would submit. They use...
Somebody going out to, in the 18th century, someone going to hunt a deer would have thought of himself as bearing arms? I mean, is that the way they'd talk?
Yes, you are bearing an arm. You just aren't bearing it in a defensive posture. You are bearing it to hunt. It is still bearing an arm. The amount of stupid you get when you put a bunch of lawyers in a room is amazing to me, which actually leads into the fact that a bunch of our representatives and Congress people are lawyers, much like Hank Johnson, who literally thought a island would tip over like it was a fucking bobber.
Well, I mean, I will grant you this, that bear arms in its unmodified form is most naturally understood to have a military context. Yeah. But I think the burden of the argument on the other side is to make it have an exclusively military context. And as a number of the briefs have pointed out, that's not borne out by the framing sources. And one place, although it's not bearing arms, it's bearing a gun, I think it's highly relevant that Madison and Jefferson, with respect to this hunting bill that Jefferson wrote and Madison proposed, specifically used in the hunting context the phrase bear a gun. And so I do think in that context...
But it's arms that has the kind of the military, the martial connotation, I would have thought.
Wasn't it the case that the banning of arms on the part of the Scottish Highlanders and of Catholics in England used the term, forbade them to bear arms? It didn't mean that they could just not join militias. It meant they couldn't carry arms.
And again, I think various phrases were used. I also think that some of the disarmament provisions specifically use the word keep. And so I think there is some independent meaning there, which is one point. And then I do think that even in the context of bearing arms, I will grant you that arms has a military connotation, and I think Miller would certainly support that. But I don't think it's an exclusively military connotation.
Not Miller, but the Massachusetts Declaration, the right to keep and bear arms for the common defense is what is the normal reading of it.
Oh, absolutely. And I grant you, if the Second Amendment said keep and bear arms for the common defense, this would be a different case. But
right to keep and bear, it isn't. I'm sorry. It's one right to keep and bear, not two rights to keep and to bear.
Well, I mean, it's my friends from the district that are emphasizing that no word in the Constitution is surplusage. So I would say that in a context like this, you might want to focus both on keep and on bear arms.
And you want to talk about the standard and your light's on.
Okay. I would like to talk about the standard, and my light is indeed on, so let me do that. I think there are several reasons why a standard, as we suggest in our brief, rather than strict scrutiny, is an appropriate standard to be applied in evaluating these laws. I think first and foremost, as our colloquy earlier indicated, there is the right to bear arms. It was a pre-existing right. The Second Amendment talks about the right to bear arms, not just a right to bear arms. And that pre-existing right always coexisted with reasonable regulations of firearms. And as you pointed out, Justice Souter, to be sure, when you're making the translation from the English Bill of Rights, you always have to deal with parliamentary supremacy. But it is very striking that, as Justice Stevens said, the right was conditioned on the conditions, which I think meant what class you were, and also subject expressly to the laws of Parliament.
The freedom of speech that was referred to in the Constitution was also the freedom of speech, which referred to the pre-existing freedom of speech. And there were indeed some restrictions on that, such as libel, that you were not allowed to do, and yet we've never held that simply because it was pre-existing and that there were some regulations upon it that we would not use strict scrutiny. We certainly apply it to freedom of speech, don't we?
Well, Justice Scalia, let me make two related points. One, even in the First Amendment context, this Court has recognized, and I'd point you to the Court's opinion in Robertson against Baldwin, which makes this point as to both the First and the Second Amendment. This Court has recognized that there are certain pre-existing exceptions that are so well established that you don't really even view them as Second Amendment or First Amendment infringement.
Like libel.
Like libel, and I would say like laws barring felons from possessing handguns.
Or would you say like protecting yourself against intruders in the home?
Well, that gets to the self-defense component, and I don't know that I ever got a chance to fully answer your question on that, Justice Kennedy, which is we would say, notwithstanding the fact that the preamble makes it clear that the preeminent motive was related to ensuring that the militia remained a viable option vis-a-vis the standing army, the operative text is not so limited. And I think in that regard, it's worth emphasizing that the framers knew exactly how to condition a right on militia service, because they did it with respect to the grand jury clause.
Well,
and they didn't do it
the
with
amendment
respect
is
to the Second
intended, at least in part, to protect the right to self-defense in the home, how could the district code provisions survive under any standard of review where they totally ban the possession of the type of weapon that's most commonly used for self-defense, and even as to long guns and shotguns, they require at least what the code says without adding a supposed gloss that might be produced in a subsequent case, that even as to long guns and shotguns, they have to be unloaded and disassembled or locked at all times, even presumably if someone is breaking into the home.
Well, Justice Alito, let me answer the question in two parts if I can, because I think the analysis of the trigger lock provision may well be different than the analysis of the other provisions. With respect to the trigger lock provision, we think that there is a substantial argument that once this Court clarifies what the constitutional standard is, that there ought to be an opportunity for the District of Columbia to urge its construction, which would allow for a relatively robust self-defense exception to the trigger lock provision. And this Court could very well, applying Ashwander principles, allow for that kind of interpretation.
I don't understand that. What would that be? That you can, if you have time, when you hear somebody crawling in your bedroom window, you can run to your gun, unlock it, load it, and then fire. Is that going to be the exception?
If that's going to be the exception, it would clearly be inadequate. And I think that, I mean, the District of Columbia can speak to this, but it seems to me that if, for example, the...
Brother, I think you can, if you look, get some 80% receivers for shotguns. It's been a while since I've looked into it, but it's nowhere near as popular as 80% for 1911s, for Glocks, SIGs, ARs, AKs, but I think you can find some. It's just a matter of sourcing out the parts. Yes, Cat. Jesus Christ.
Police were executing a warrant at evening and had cause for doing it at evening and saw somebody with a loaded gun on their nightstand with no children present and without a trigger lock, it seems to me that that would be a good test case to decide whether or not their construction would provide for an exception to the trigger lock provision in that case. If it did, I think then the statute might well be constitutional. If it didn't, in my view, it probably wouldn't be.
There's a lot of talk about standards and stop words like strict scrutiny. Does it make a practical difference whether we take your standard or the strict scrutiny that was in the D.C. Circuit's opinion, and specifically there's a whole panoply of federal laws restricting gun possession. Would any of them be jeopardized under your standard? And the same question with the strict scrutiny. Does it make any difference?
In our view, it makes a world of difference, Justice Ginsburg, because we certainly take the position, as we have consistently since 2001, that the federal firearms statutes can be defended as constitutional, and that would be consistent with this kind of intermediate scrutiny standard that we propose. If you apply strict scrutiny, I think that the result would be quite different, unfortunately.
Well, these various phrases under the different standards that are proposed, compelling interest, significant interest, narrowly tailored, none of them appear in the Constitution. And I wonder why, in this case, we have to articulate an all-encompassing standard. Isn't it enough to determine the scope of the existing right that the amendment refers to, look at the various regulations that were available at the time, including you can't take the gun to the marketplace and all that, and determine how this restriction and the scope of this right looks in relation to those? I'm not sure why we have to articulate some very intricate standard. I mean, these standards that apply in the First Amendment just kind of developed over the years. It's sort of baggage that the First Amendment picked up, but I don't know why when we're starting afresh we would try to articulate a whole standard that it would apply in every case.
Well, Mr. Chief Justice, let me say a couple of things about that, which is to say that if this court were to decide this case and make pellucidly clear that it really was focused very narrowly on this case and it was in some respects applying a sui generis test, we think that would be an improvement over the Court of Appeals opinion, which is subject to more than one reading, but as Justice Ginsburg's question just said, is certainly susceptible to a reading that it embodies strict scrutiny.
Well, it did. It said it's just like the First Amendment. First Amendment has exceptions, but strict scrutiny applies. It says
what are you
scrutiny
doing?
Applies here too.
But that opinion also did use the militia prologue to say it's only the kind of weapons that would have been useful in the militia and that are commonly held today. Is there any federal exclusion of weapons that applies to weapons that are commonly held today? I don't know what you're worried about. Machine guns? What else? Armored bullets? What else?
Well, Justice Scalia, I think our principal concern, based on the parts of the Court of Appeals opinion that seem to adopt a very categorical rule, were with respect to machine guns, because I do think that it is difficult. I don't want to foreclose the possibility of the federal government making the argument someday, but I think it is more than a little difficult to say that the one arm that's not protected by the Second Amendment is that which is the standard issue armament for the National Guard, and that's what the machine gun is.
This law didn't involve a restriction on machine guns. It involved an absolute ban. It involved an absolute carry prohibition. I mean, why would you think that the opinion striking down an absolute ban would also apply to a narrower one directed solely to machine guns?
I think, Mr. Chief Justice, why one might worry about that is one might read the language on page 53A of the opinion as reproduced in the petition appendix that said once it's an arm, then it is not open to the district to ban it. Now, it seems to me that the district is not strictly a complete ban because it exempts pre-1976 handguns. The federal ban on machine guns is not strictly speaking a ban because it exempts pre-law machine guns, and there are something like 160,000 of those.
But that passage doesn't mean once it's an arm in the dictionary definition of arms, once it's an arm in the specialized sense that the opinion referred to it, which is the type of a weapon that was used in militia and that is nowadays commonly held.
Well,
if you read it that way, I don't see why you have a problem.
Well, I hope that you read it that way. But I would also say that I think that whatever the definition that the lower court opinion employed, I do think it's going to be difficult over time to sustain the notion. I mean, the Court of Appeals also talked about lineal descendants. And it does seem to me that, just as this court would apply the Fourth Amendment to something like heat imagery, I don't see why this court wouldn't allow the Second Amendment to have the same kind of scope. And then I do think that reasonably machine guns come within the term arms. Now, if this court wants to say that they don't, I mean, we'd obviously welcome that in our obligation to defend the constitutionality of acts of Congress. The one other thing I would say is that this is an opinion that is susceptible of different readings. It's interesting that respondents amici have different characterizations of it. The Goldwater Institute calls it strict scrutiny. The state of Texas calls it reasonableness review.
Thank you, General.
Thank you.
Mr. Gura?
Thank you, Mr. Chief Justice, and may it please the Court. All 50 states allow law-abiding citizens to defend themselves and their families in their homes with ordinary functional firearms, including handguns. Now, I'd like to respond to one of the points that was raised lately by the General.
Talk a little slower. I'm not following you.
Okay. I'd like to respond, certainly Justice Scalia. I'd like to respond to the point about the District of Columbia's position over the years with respect to the functional firearms ban. The petitioners have had two opportunities to urge courts to adopt this so-called self-defense exception that they construe in the amendment. The first opportunity came in 1978 in McIntosh versus Washington, where the petitioners urged the Court of Appeals of the District of Columbia to uphold the law because it was rational in their view to prohibit self-defense in the home with firearms. They deemed it to be too dangerous and that this was a legitimate policy choice of the City Council, and they actually prevailed in that view. The second opportunity that the petitioners had to urge this sort of self-defense construction was actually in this case, in the district court. We had a motion for summary judgment to make certain factual allegations in this motion, and on page 70A of the joint appendix, we see portions of our statement of undisputed material facts. Fact number 29, which was conceded by the District of Columbia, reads, "The defendants prohibit the possession of lawfully owned firearms for self-defense within the home, even in instances when self-defense would be lawful by other means under District of Columbia law." The citation for that is the functional firearms ban, and that point was conceded. Certainly, the idea that people could guess as to when it is that they might render their firearm operational is not one that the court should accept, because a person who hears a noise, a person who perhaps is living in a neighborhood where there's been a spate of violent crimes, has no idea when it is that the District of Columbia would permit her to render the firearm operational. And in fact, there is a prosecution history, not under this specific provision, but certainly under other gun prohibition laws that we're challenging here today, to prosecute people for the possession or for the carrying of a prohibited firearm, even when the police rule the shooting has been lawful self-defense, where there's no prosecution for assault or attempted murder or anything of that.
You're saying that this is unreasonable, and that really is my question, because I'd like you to assume two things with me, which you probably don't agree with, and I may not agree with them either, but I just want you to assume them for the purpose of the question. All right? Assume that there's an individual right, but the purpose of that right is to maintain a citizen army, call it a militia. That's the basic purpose. So it informs what's reasonable and what isn't reasonable. Assume
absolutely.
It's favorable to you, but not as favorable as you'd like. Assume that we're going to decide whether something is proportionate or apply an intermediate standard in light of the purpose. All right? Now focus on the handgun ban. As I read these 80 briefs, and they were very good, I mean really good and informative on both sides, and I'm trying to boil down the statistics where there's disagreement. And roughly what I get, and don't quarrel with this too much, it's very rough, that 80 to 100,000 people every year in the United States are either killed or wounded in gun-related homicides.
Yeah, let's throw those numbers together, you complete fucking jackass. He just put in every freaking category of someone getting injured or killed with a firearm into one lump sum to inflate the numbers. And this is the guy who basically trained the judge who will take his spot. Luckily enough for us right now, she's not going to change the balance of the Supreme Court. Supreme Court's still going to be split 5-4. Sometimes you can't depend on a certain justice to actually stick with people who are for freedoms and rights and individual liberties. But it's still pretty much a 5-4 court, and it's going to remain a 5-4 court unless Joe Biden goes on with his plans to actually pack the court. If he does that, well, then it's just going to be like fucking Armageddon, and everybody's going to keep adding justices to the Supreme Court until, fuck, we'll all be members of the Supreme Court before too long. They'll just be running ads in the goddamn paper needing Supreme Court justices.
Or crimes or accidents.
Yeah, Crow. 92 million, baby. Okay. So you're telling me a third of the United States suddenly drops dead every year from firearms? Seems like we'd all be gone by now. Although stupid people are breeding faster than fucking rabbits. So there is that. Yeah, the numbers, when you take the numbers of firearms owners, the number of firearms in the United States, and the number of people in the United States, actual injuries and deaths from firearms are exceedingly low. As a matter of fact, doctors, through mistakes, we'll say mistakes, kill way more people than firearms every year. There's a, oh God, where did I put it? I'd have to show it on, I'll try to do it on another stream. It's part of the CDC's website where you can go in and you can actually list different causes of death and compare them. And when they get into categories like, say, innocent children getting killed by firearms, more children will drown in home incidents than are killed by firearms. But they play with those numbers too, and you've got to really watch how they do it. It's the same reason they add in suicide deaths to violent deaths involving firearms. They have to inflate the numbers. Because if you took someone with half of a fucking brain and they looked at, again, the number of deaths from other causes, the number of deaths from firearms, the number of people in the United States, and started to compile all that data, you would see that firearms deaths in the United States are, in fact, extremely low versus the population of the United States. But people don't want to actually look at the numbers. Yeah, 250K medical malpractice deaths. Yeah, that's an average. If you, I'll be very careful about how I say this. If you looked at things that happened involving the and the way that patients were treated that had said, you would see that the hospitals killed many thousands of people because they refused to treat patients for actual effects. And here we are again talking about firearms, which fucking McDonald's kills more people than goddamn firearms every year. But hey, Mom's Demand and Giffords Institute in every town, they will stand on every stack of fucking bodies that they can possibly stand on because they just don't like guns.
Or suicides, but suicides are more questionable. That's why I say 80 to 100,000. In the district, I guess the number is somewhere around 200 to 300 dead, and maybe if it's similar, 1,500 to 2,000 people wounded. That's exactly what I'm talking about, Alex.
apparently you are a informed individual, which we can't say that about the vast majority of citizens of the United States at this point. But yeah, that's pretty much the size of this. This right here, this smoky thing that I do is definitely way more dangerous than this thing that goes bang bang. At least to my health, anyway.
All right. Now, in light of that, why isn't a ban on handguns, while allowing the use of rifles and muskets, a reasonable or a proportionate response?
While allowing the use of rifles and muskets. And that's all I have to say about that.
On behalf of the District of Columbia.
Because, Your Honor, for the same reason that was offered by numerous military officers at the highest levels of the U.S. military at all branches of service, writing in two briefs, they agree with us that the handgun ban serves to weaken America's military preparedness, because when people have handguns are military arms, they're not just civilian arms. They are better prepared and able to use them, and certainly when they join the military forces, they are issued handguns. And so if we assume the sort of military purpose to the Second Amendment as an individual right, then the handgun ban, as noted by our military amici, would impede.
I read the two military briefs as focusing on the nature of the right. It was quite a pretty good argument there, that the nature of the right is to maintain a citizen army. And to maintain that potential today, the closest we come is to say that there is a right for people to understand weapons, to know how to use them, to practice with them. And they can do that. You see, with their rifles, they can go to gun ranges, I guess, in neighboring states. But does that make it unreasonable for a city with a very high crime rate, assuming that the objective is what the military people say, to keep us ready for the draft if necessary? Is it unreasonable for a city with that high crime rate to say no handguns here? Now,
you want to say
why?
Yes, that's your answer.
Yeah, well, you want to say.
Is it unreasonable for a city to go no handguns here? Let's break this down. Yes, that is unreasonable, because those of us who legally carry firearms for self-defense are not out there committing crimes. In fact, those of us that are legal gun owners tend to be the most law-abiding citizens on this planet. And we use those firearms defensively anywhere from 500,000 to 3 million times a year to legally defend our life, liberty, and property. Again, the judge, Jackson Brown, who is going to take over for this jackass, is way more left than he is when it comes to firearms. Otherwise, she would not be Joe Biden's pick. And I'm going to run till about 6, and then I'm going to try to get a little bit of sleep, because I do want to try to cover Brown Jackson's confirmation hearing here in just a couple hours. So I'm going to run this just a little bit longer, and then I'm going to bail.
Yes, that's correct. But I want to hear what the reasoning is, because there's a big crime problem. I'm simply getting you to focus on that.
The answer is yes, as Justice Scalia noted, and it's unreasonable and it actually fails any standard of review that might be offered under such a construction of the individual right, because proficiency with handguns, as recognized as a matter of judicial notice by the First Circuit in Casas back in 1942, that was a handgun case where the First Circuit examined the restriction on the carrying of a .38 caliber revolver, and the First Circuit accepted, as a matter of judicial notice, that proficiency in use and familiarity with the handgun at issue would be one that would further a militia purpose. And so,
this question, in answering yes, do you attach any significance to the reference to the militia in the Second Amendment?
yes, I do, Your Honor.
You think that is, to understand the amendment, you must pay some attention to the militia requirement?
Yes, Your Honor, we must.
So a conscientious objector who likes to hunt deer for food, you would say has no rights under the Second Amendment. He's not going to be part of the militia. He's not going to be part of the
Some people have a
Defense.
parrot on their
You would
shoulder. I
say
have a
that
cat.
He doesn't have any rights under this amendment?
No, Your Honor. I think that the militia clause informs the purpose, it forms a purpose. It gives us some guidepost as to how we look at the Second Amendment, but it's not the exclusive purpose of the Second Amendment. Certainly the founders cared very much.
Is it a limitation, is it any limitation on the legislature? Is the first clause any limitation on the legislature?
Yes, there's an absolute limitation on the legislature. The Second Amendment was a limitation on government power. This troll being off the Supreme Court was one of the best things that could have ever happened to the Supreme Court. Just saying. Yeah, you're right. They're completely arguing off of the terms set by their opposition instead of, what the fuck are you doing, cat? Anybody want a cat? I'm going to box him up and ship his ass to Zimbabwe. Maybe Taiwan. Korea. Where do they eat cats?
It is a limitation to one extent, Your Honor. The extent recognized in Miller, where the Miller court asked whether or not a particular type of arm at issue is one that people may individually possess. They looked at the militia clause and therefore adopted a militia purpose as one of the two prongs of Miller. And so certainly if there were, if the court were to continue Miller and Miller was the only guidance that the lower court had, certainly, as to what arms are protected or unprotected by the Second Amendment, then yes.
If it limits the kind of arms to be appropriate to militia, why does it not also limit the kind of people who may have arms?
It does not eliminate the kind of people, Your Honor, because the Second Amendment is the right of the people, and it would certainly be an odd right that we would have against the Congress if Congress could then redefine people out of that right. Congress could tomorrow declare that nobody's in the militia, and then nobody would have a right against the government.
If you were thinking of the people, what those words meant when the Second Amendment was adopted, it was males between the ages of, what, 17 and 45? People who were over 45.
What are you doing?
They didn't serve in the militia.
Well, certainly there were many people who were not eligible for militia duty or not subject to militia service who nevertheless were expected to, and oftentimes did, in fact, have guns.
Which shows that maybe you're being unrealistic in thinking that the Second Clause is not broader than the First. It's not at all uncommon for a legislative provision or a constitutional provision to go further than is necessary for the principal purpose involved. The principal purpose here is the militia, but the Second Clause goes beyond the militia and says the right of the people to keep and bear arms. Now, you may say the kind of arms is colored by the militia, but it speaks of the right of the people. So why not acknowledge that it's broader than the First Clause?
I'm gonna lock you on the damn room.
Why have the First Clause? I mean, what's it doing? I mean, what help is it going to be?
Well, it was a way in which to remind us, the framers certainly felt that a militia was very important to the preservation of liberty. The framers had just fought a revolutionary war that relied heavily on militia forces, and so they wanted to honor that and remind us as to the purpose, one purpose, not the exclusive purpose, but a purpose of preserving the right of the people.
It would also be simply to reaffirm that the provisions in the main text of the Constitution remained intact.
That's correct, Your Honor. In fact, that view was taken by William Raleigh in his 1828 treatise, View of the Constitution. Raleigh, of course, was a ratifier of the Second Amendment. He sat in the Pennsylvania Assembly in 1790, and if we look at his description of the Second Amendment, he bifurcates it. First, he discusses the militia clause, and he lavishes some qualified praise on it, and then
You were about to tell us before a course of questioning.
Hey, didn't we go over bifurcate and safety dock stream earlier tonight, Bacon? You know, something that was split. Here we go. See, I mean, safety doc knows what he's talking about.
Began about the other purposes that the amendment served. I want to know whether or not, in your view, the operative clause of the amendment was designed to protect in an earlier time the settler in the wilderness and his right to have a gun against some conceivable federal enactment which would prohibit him from having any guns.
Oh, yes. Yes, Justice Kennedy. The right of the people to keep and bear arms was derived from Blackstone. It was derived from the common law English right, which the founders wanted to expand. In fact, the chapter in which Blackstone discusses in his treatise his fifth auxiliary right to arms is entitled...
That brings me back to the question, because Blackstone describes it as a right to keep and bear arms under law.
Yes, you jackass. And like the man just said, they wanted to expand on Blackstone. They didn't want to limit it as Blackstone was talking about the way it was limited at that time in England, because Blackstone understood that it's pretty much useless to have any sort of firearms rights or right to arms if the government can just strip those away from you and then rape the shit out of you. Our founders were some very smart gentlemen, and knowing that they were fixing to fight a battle against the most powerful army in the world, enlisted private citizens and the private citizens' own arms to aid in that fight against said king and his army. I will fall back to a point I've made many times so far. Why the hell they don't bring up the founders' supporting letters to the Second Amendment, I have no idea, because they explained it in much more detail than just what is said in the Second Amendment. Yeah, Bacon, you got me.
He uses the words under law. He clearly foresees reasonable regulation of that right. And so does the case not hinge on, even given all your views, on whether it is or is not a reasonable or slightly tougher standard thing to do to ban the handgun while leaving you free to use other weapons? I noticed that the malicious statute, the first one, spoke of people coming to report in 1790 or whenever with their rifles, with their muskets, but only the officers were to bring pistols. So that to me suggests they didn't see pistols as that crucial, even.
That's because the technology had not advanced far enough for pistols to be a very useful object. You absolute moron. And now we have his protege going to take his spot. Oh, boy.
Then, let alone now.
Well, certainly they saw.
What's your response is the question.
Well, my response is that the government can ban arms that are not appropriate for civilian use. There's no question of that. And it's.
There is an absolute question of that. Nowhere in the Constitution, in the Second Amendment, does it mention the types of arms that we as the people can own. It merely says that we have the right to own arms and bear arms, keep arms. It doesn't say that those arms have to be a certain category. Doesn't say they have to be a pistol, they have to be a rifle, they have to be a shotgun. Doesn't say they can't be a howitzer, they can't be a Sherman tank, they can't be an M1 Abrams. Nowhere in the Constitution does it mention that.
That are not appropriate.
That are not appropriate to civilian use.
For example?
For example, I think machine guns. It's difficult to imagine a construction of Miller or a construction of the lower court's opinion that would sanction machine guns or the plastic undetectable handguns that the Solicitor General spoke of. The fact.
Again, this is the guy who is, I believe, supposed to be defending the Second Amendment. Was he like the only one left on the bench that wasn't injured or something, and they just had to call him up from the third string?
Is that this court's Miller test is the only guidance that we had below, and I think it was applied faithfully. Once a weapon is, first of all, an arm under the dictionary definition, and Webster has a very useful one, then you look to see whether it's an arm that is meant to be protected under the Second Amendment, and we apply the two.
That is a perfect point. A debate on how much we should restrict and not, whether we should restrict it at all. That is, yes, perfect. And you're making a great point there, and I will bring that down to said Republicans in our Congress that are not against gun control. They merely slow down gun control because the way the Democrats push them around, we end up with things like the 34 NFA. We end up with things like the 68 GCA. We end up with things that are supposed to be the Gun Owners Protection Act that further restricts our right to own arms. And the Democrats, the leftists, I should say, just keep taking one chunk and another chunk and another chunk and another chunk. What you have to realize with them is their only goal is to win. They don't care when they win. They would like to win quickly, but they don't ultimately care how long it takes. It's just this steady chipping away at the right itself. And just like we saw with this omnibus bill, these idiot ass Republicans will vote for this shit. And just keep giving away and giving away and giving away and giving away. And the good old NRA, well, they're worried about making money for homeboy suits and not defending our rights. And why the hell the NRA is still fucking relevant baffles me. Right now, presently in the United States, there are probably in the neighborhood of 100 up towards 150 million gun owners. There are roughly under 5 million people who support the NRA. tell me again why they are relevant. I still ain't figured that shit out yet, besides the fact they have some historical clout. You know, I just joined the GOA just about a week ago. And the reason I joined them is they may not be perfect, but they are out there taking a swing at this shit and actually trying to fight. So, and it took me a very long time to join them. I'm not a joiner, but seeing the actions that they are actually taking to defend our rights, they were worth the fee to kind of support them. Yeah, dude, Alex, you're right again. It's the people with the money that can grease the palms, grease the wheels, that ultimately decide what happens. And again, that's one of the reasons I went ahead and joined the GOA, because they are fighting. They do have some clout. They are spending some money. So, I mean, why not support that group? Especially with what we're seeing now and what we are waiting to come this summer with these ATF rule changes that are coming. So, yeah, Crow, I'm with you, man. I'd never joined another group before until I've literally watched what the GOA's been trying to do for the last, I don't know, couple of years since I've been paying attention to them. And, you know, hell, they're at least swinging, man. They're not just standing there taking the punch. They're at least in the fight. So, but I tell you what, guys, I'm going to end this here. I'm going to try to get a little bit of a nap in, and hopefully, if everything works out, I'm going to start another stream up to cover the hearings on our illustrious Supreme Court justice that is going to replace Stephen Breyer. Today will be a little bit different than yesterday. Yesterday was pretty much all introductions and the niceties that come along with that. So I'm hoping today there will be some people that will actually start asking some serious damn questions to this chick. And yeah, Bacon, I do sleep sometimes. I actually do like to sleep. I just tend to be an insomniac. So it's just the way it is. But like I said, I'm going to try to get a little bit of sleep. I think these hearings start about 9. So hopefully I will be starting back up here in just, I don't know, a couple hours. But anyway, you perps be cool. I am out for right now. I'm going to get a little bit of sleep and then hopefully crank this shit right back up. So you guys be cool. Have a good morning. If you guys are up in a little while, keep an eye out, because I don't know when I'll start, but I'm just going to pop another stream back up. There's not going to be a whole lot of warning on it. So anyway, y'all take it easy, guys. Be cool. Adios later, and we'll catch you in a little while.